There we go. Is that working? Let's see here. Everybody on? Okay, that's on. Hi. I still don't have anything from the court. Okay, good. Whew. All right, and let's make sure that I have all of my, I think everybody's visuals are connected. And Vashon/Oregano, would you do me a favor and test one of the graphics for me? I think I set them up separately for the different. Okay, does that work for you? I couldn't see it over on the small window, so did it look right? Okay, good. I think. Now, one thing, if it looks funky, I can't remember if it gives us trouble if they're uppercase, lowercase. You're on Substack, and it only shows my logo. Still unsweetened anti-tea? That's very weird. Okay, hold on one second. I'm here now, okay. That's weird. It may have to be something I figure out why that's, I have no idea why that happened. So I'm gonna restart let me try reloading the oral arguments website because it should have started by now. I'm not sure why we're not getting, let me try.
No connection to the bankruptcy, and it unfairly
Can you guys hear audio?
penalizes honest debtors by denying them redress for real wrongs. This court should reject the Fifth Circuit's rule and hold instead that courts must undertake a holistic analysis of all facts bearing on a debtor's intent before concluding that a debtor's failure to update a form represents an intentional position that no cause of action exists. Erasing a debtor's claim seeking redress for tortious or other illegal conduct, like petitioner's personal injury action here, imposes an enormous cost on individuals already facing hard times. There's no basis for taking that extreme step based on a conclusive presumption that may be entirely unfounded. I welcome the court's questions.
Mr. Garr, what type of evidence should be used in your holistic approach?
So we would look to all surrounding circumstances, Your Honor, objective and subjective. It would include the debtor's own testimony, typically, but that would just be one factor. You'd look at the sophistication of the debtor, when and the manner in which the debtor updated the form, whether the debtor told his attorney of the cause of action, whether creditors objected when a form was amended, the impact on creditors or others in the bankruptcy court's own findings. These are objective factors that courts have looked to and can be applied in determining a debtor's actual intent.
One factor you haven't mentioned is, of course, the impact on the judiciary, the judicial reputation, sort of phrases that have traditionally been used here. All that you've been talking about is between the two parties to the bankruptcy and the accident. Where does that factor in? I thought that was the primary basis for the whole doctrine of judicial estoppel. You don't want to put the courts in the position
Sorry,
of
guys.
acting on the
This is the
basis
wrong
of a
case.
counterfactual. That's not true.
Absolutely, Your Honor. That's the backbone of judicial estoppel. This court and others have talked about playing fast and loose in the courts, with the courts, and protecting the integrity of the courts. And what this court recognized in New Hampshire is that where the integrity is impacted is where parties intentionally advance inconsistent positions in order to gain advantage in litigation. And to put the courts in the position of potentially adopting those inconsistent positions is what undermines the integrity of the courts.
I thought it was more that they had proceeded on the basis of a particular, not assumption, but what was shown, and you don't want to put them in a position of having two different versions of reality and then proceeding on the basis of one or the other.
So I think what the courts have described it as is the cold manipulation of the process, Your Honor, and that happens when an individual intentionally takes one position, secures an advantage by the adoption of that position, turns around in a different proceeding, adopts a different position, and tries to get a different advantage. If the individual didn't intentionally adopt that first position and corrects it, as happens in the scenario here, where a debtor is simply unaware, and as the amici former bankruptcy judges indicate, bankruptcy forms are very confusing. Even with the aid of counsel, many debtors simply just don't realize
You guys heard me say
the cause
that.
of action is an asset.
Nobody
forms have
gets
to be
bankruptcy.
updated. In that situation, the debtor has made simply a mistake in failing to update the court as to the existence of the cause of action. And there, the debtor is not actually taking the position that there is no cause of action before the bankruptcy court. He simply failed because of his mistake to update a form. So there is no intentional inconsistency. There's no playing fast and loose with the courts. There's no cold manipulation of the judicial process. And there's no threat to the integrity of the court. And conversely, I mean, judicial estoppel is an extreme measure, and it's appropriate where there is a threat to the integrity of the court, but it involves wiping out a cause of action. And here you have a situation in which courts, without even engaging in a holistic determination as to the debtor's actual intent, whether the debtor simply made a mistake in failing to update a form, are wiping out a cause of action like Mr. Keathley's personal injury action here. The respondent's own driver admitted that his brakes failed and that his truck hit Mr. Keathley's, and that action has been wiped out based on a conclusive presumption that the Fifth Circuit applies, that simply because a debtor has a potential financial motive to mislead, a debtor's failure to update the bankruptcy court as to the existence of a cause of action.
Jackie, I have
is
a
an
respondent,
intentional,
or a big response to you.
representation.
Mr. Gar, can
Hold
I
on.
interrupt you and ask you a question? This is an eerie
I
question.
don't want to interrupt, but
This was a diversity suit, so why does the federal law, everyone's assumed that the Fifth Circuit's law of judicial estoppel applies? Is the Mississippi law different? And if not, why doesn't the Mississippi law control in the diversity suit under Erie?
So I think, as I understand this court's decision in New Hampshire versus Maine, I mean, the judicial estoppel doctrine as embraced by this court is, a federal law, common law type rule inherent in the court's own authority to protect its proceedings. And so I think that would be a federal baseline. I mean, state courts have applied it as well. I think here, no one has pointed to any difference in the proceedings.
I gather that it's a matter of some dispute in other circuits, that courts have struggled with that question, and I don't want to resolve it here. I don't think we have to resolve it here, but I certainly wouldn't want anything we said here to resolve that question. I mean, I can see arguments on either side. I think what you're saying might be kind of a Bird versus Blue Ridge. The overriding federal interest overcomes whatever we might say about the outcome determinative prong of Erie. It just seems to me like that might be something, I just wanted to know your reaction about it because it might be something to avoid.
So I think the court, can and absolutely should reserve that question for a later day. Your Honor, I'm not aware of any inconsistency in state or federal courts in terms of recognizing that judicial estoppel doctrine wouldn't apply in the case of an honest mistake. I think courts across the board have focused on what they call the cold manipulation of the courts and the judicial process.
Okay, just one last question then. Speaking of just questions to avoid, do you see your argument is really kind of confined to how judicial estoppel plays out in the bankruptcy context in particular? Or do
Yes.
you see it, okay, why?
Yes. Well, that's the situation, and this has arisen. I mean, it's unique in the important respect is typically when a judicial estoppel has applied in other contexts like New Hampshire versus Maine, you have a party that's affirmatively adopted two different positions. And there's no question what the party thinks his position is. Here, in the bankruptcy context where a debtor has failed to update a form, the position is implied by the failure to update the form, but the debtor hasn't actually affirmatively said, I have no cause of action. Where judicial estoppel is invoked, there's a presumption in the Fifth Circuit that the debtor, in fact, made that representation. So that the context is different in important ways. In New Hampshire, this court, in outlining general principles that typically apply, recognize that additional considerations would be appropriate in specific factual contexts. So I think the context here is important. Also, in this context, you have individuals who, very often are not particularly sophisticated. You have an environment, bankruptcy, where forms are complex. Again, amici former bankruptcy judges here and themselves have talked about the complexity of the forms, confusing, even with the aid of counsel. And so I think that's the situation, in particular this context, where one would be wary about there was any position at all, or whether a debtor simply made an honest mistake in failing to update a form.
Mr. Gar, I've been having trouble trying to fit in our New Hampshire principle to the bankruptcy context, where the bankruptcy, it has not terminated. Meaning, in a situation like this one, where the bankruptcy is still ongoing, because logically and otherwise, it should be the bankruptcy court that decides whether to impose a penalty. Because doing away with the personal injury suit deprives the creditors of a potential source of income for the bankruptcy. In an ongoing bankruptcy, that's a draconian effect on the creditors that the second court would be imposing. So I'm not sure how equitable estoppel really can play out on the principles set forth in New Hampshire. New Hampshire said that the court, the first court had to be persuaded to accept that party's earlier position. But here, with the amendment, there was no permanent acceptance of a position by the bankruptcy court. It also, how New Hampshire said, a court has to consider whether the party seeking to assert an inconsistent position derived an unfair advantage or imposed an unfair detriment on the opposing party. But the opposing party here, there's no unfair detriment to the man who hit your client with a truck because he wasn't involved
somebody
in the
left their cell
bankruptcy.
phone on.
And the unfair advantage was wiped away once the disclosure was made in the bankruptcy court. So I'm a little bit, I've been perplexed when I started with this, how we deal with that context in this special situation where the bankruptcy has not terminated. There's been no final determination that the bankruptcy court was misled in a way that caused detriment to the bankruptcy process, to its creditors, or to
Okay, we're
anyone.
getting closer to my read on
So I'm
this
not going to
now.
quarrel with anything that would lead to the conclusion that judicial estoppel doesn't wipe out my client's claim, Your Honor.
No,
I think what I would
but
say,
I'm
though,
trying
is
to, maybe this is a question for the other side, but I've been having a hard time understanding how this theory works in a situation in which it's different parties and not the same parties being misled.
So in New Hampshire, the court did reference a possibility that either the first court or the second would be misled, and I think that's probably the theory that courts have applied here. I think what Your Honor's question underscores, though, is that here, the bankruptcy court, you have a proceeding ongoing, the bankruptcy court is well equipped to take any action it determines is appropriate to protect other creditors. Other creditors can stand up as well to sanction conduct that it believes is misleading or deceitful. And so there's not the need for a sort of overarching judicial estoppel check here. And that makes it all the more egregious, frankly, for the Fifth Circuit to simply disregard all that and adopt this conclusive presumption that a debtor is acting with an intent to adopt a position that no cause of action exists and to mislead the courts.
Mr. Garr, can I ask you, because I'm trying to ascertain your position with respect to what suffices for establishing inadvertence or mistake. You've talked about intentional omissions as they relate to misleading the courts, but you can imagine a world, I think, in which the debtor might have an intent to omit, perhaps to mislead someone else. So, a debtor who's, say, contemplating a divorce, they leave off the claim because they want to have less exposure in the case if they decide to go through with the divorce. So it's intentional, but not with the point of misleading the court. How would you say that should be taken into account, or should it, in regard to figuring out whether there was inadvertence or mistake?
So, Justice Jackson, I think, first of all, that the key is that the court has to determine that the debtor has adopted an intentional position that no cause of action exists. I think that the heartland in which judicial estoppel is invoked, the understanding is that the debtor is trying to mislead the court to gain advantage. And your hypothetical, I don't think that would invoke the heartland of judicial estoppel. Nevertheless, I think judicial estoppel being an equitable doctrine, considering additional factors, that could be part of the mix.
All taken into account in terms of your holistic view. And so your argument here is that the Fifth Circuit's test is too rigid because it doesn't allow for full consideration of intent or other factors that could bear on inadvertence or mistake.
I don't know, Jim.
That's exactly right. I mean, our position is that the inquiry into the debtor's intent here as to whether they intentionally adopted a position that no cause of action exists should be undertaken.
But does it matter that their motive is different? I mean, so in my hypothetical, they did intend. They intended to omit. So it's not
I guess just
inadvertent
hit
or
like
mistaken.
Best we can do for now.
What then? I mean,
So I think that, I'm sorry,
Yeah.
Your Honor.
No,
I
I'm
think
just-
that's a good example where, really the bankruptcy judge is in charge of his or her proceedings and can take appropriate action. In that situation, no doubt the judge would think it's improper and perhaps warrant sanction that the debtor is attempting to hide his assets from his spouse or others, and so sanctions might be warranted. I don't think that that's the typical fact pattern in which judicial estoppel is warranted, but I think what distinguishes this case is there's just no determination that the debtor here actually intended to hide anything from the court.
Mr. Garr, on that, just to follow up on it, why is intent to mislead the court essential? I struggle to find that in New Hampshire. There are gestures in that direction, but couldn't sometimes a knowingly misleading the court plus other factors in equity be enough?
Yes, and what the
Well,
intent...
if that's true, then intent isn't essential. It's just one factor in your view.
So I agree
that
it's
right?
one factor, but the intent that matters, Your Honor, is the intent to adopt inconsistent
Consistent positions. No, I get that, but not necessarily an intent to mislead the court.
Right. I mean, there's a lot of language in the cases about cold manipulation of the courts, plain fast and loose.
Yeah.
But really what I think that the court is driving at is intentionally adopting inconsistent positions. And what's different about this case is there's been no actual determination that the debtor here intentionally
I got
adopted
you.
the
Thank
position that there's no cause of action.
Thank you, counsel. Justice Thomas? Justice Alito?
Well, excuse me, a little confused by those answers. So what is required is knowledge of the fact that inconsistent positions are being taken?
So I think Justice Alito, it's the fact that the debtor has taken intentionally inconsistent positions. So in the bankruptcy context, by failing to update the form, a determination would be made that the debtor in fact intended to adopt the position that no cause of action exists, as opposed to simply making a mistake in failing to update a form. And when the debtor then goes to a separate court and advances this cause of action, he's taking the separate position that the cause of action exists, and that would be intentionally inconsistent. But that intentional inconsistency doesn't arise where a debtor simply makes a mistake in failing to update a form. And in that situation, the debtor isn't adopting any position that he has no cause of action. He's simply making an honest mistake. And that's so.
I'm not sure I understand the distinction in this context, but I'll leave it at that. Does the record show why the bankruptcy attorney did not list this as an asset?
It doesn't, Your Honor.
This is important.
Attorney
He told his attorney, and
did,
his
in
attorney
sworn
didn't tell
declaration
anybody.
In the record here, say that my client informed him of it, but it doesn't explain why he didn't advise the court. I mean, that's something that potentially could come out in a holistic inquiry. But I think here what matters is the debtor's intent in terms of whether or not the debtor was attempting to hide.
Well, do you think that the client in a judicial estoppel situation is to any degree responsible for the actions of the attorney?
Certainly not in the normal sense that the court ordinarily would apply the client responsibility, Your Honor, because the key here is the debtor's own intent in terms of whether the debtor was trying to hide anything, because it's the debtor who's going to a different court and asserting his cause of action. And so I think that that's a factor, and I think, frankly, the fact that the debtor here told his attorney promptly after the accident is a factor that cuts in his favor, that he wasn't trying to hide anything from the bankruptcy court. And there are many other factors that go to that, but what we really want is an opportunity for a holistic analysis that under the Fifth Circuit's rule, we never got.
Would you disagree with the proposition that where there is a duty to disclose and a potential financial interest, and the person who has that duty has a financial interest in not disclosing, that creates a pretty strong presumption of the requisite intent or knowledge?
Not in this context, Your Honor.
No?
Because here, I mean, again, the brief by the amici former bankruptcy judges themselves, piggybacking on the American Bankruptcy Institute's own findings, emphasize that these forms are confusing, hard to follow, even with the aid of attorneys. So I think in this context, we're dealing with, by and large, relatively unsophisticated people who lack legal training or the like. All of that factors into the judicial estoppel analysis here.
There are factors here that seem perhaps confined to the bankruptcy situation and to the way in which proceedings are often conducted in bankruptcy court, which I think are not always, it's not always a forum in which very meticulous compliance with all the rules apply. But I don't quite understand why the bankruptcy attorney didn't disclose. I don't quite understand why the creditors here had no interest, apparently, in having this as an asset of the estate.
Well, the creditors
Can you
were being...
explain what's going on? Is it just because this is Chapter 13 and it's not, it's just handled in a rather informal way?
So, Your Honor, I mean, that's part of it. I mean, here the creditors were paid 100% on the plan and ultimately were paid off. I mean, if any creditor had any concern about the payments on the plan or how this asset would have affected the estate, they could have taken action in the nearly 1 year between the time when Mr. Keathley advised the court of the cause of action
Not relevant.
before his
Inequity.
his bankruptcy was completed. And all of that would be part of the mix here, the fact that no creditors even complained. There's a debate
it might be relevant, but we'll come back
in
to
the
that.
law as to whether or not there was any interest available here. I mean, again, as the amici former bankruptcy judges explained, we don't think interest
might be
was
relevant.
available here, so the creditors were getting and did get everything they were entitled to.
thank you.
That might be relevant, but if it is, it
Justice
needs to be a
Sotomayor?
separate rule.
I don't know how much this personal injury lawsuit would garner, but the choice for the creditors was an unknown sum of recovery, some of which would have been paid to medical injuries and to supplement lost income versus the security of having full payment, correct?
That's correct, Your Honor.
And having the bankruptcy last forever without full payment.
That's correct. And creditors are uniquely situated to protect their own interests. If they thought anything wrong had happened or they had a stake in the cause of action, they would have acted here. No creditor objected.
Thank you.
Justice Kagan?
Mr. Gar, your brief speaks often of bad faith, of whether the debtor had bad faith in making these inconsistent representations. Are you equating that? You haven't spoken of it very much today. Are you equating it with the kind of intent that you have been talking about?
Yes. I mean, the courts refer to bad faith here in cases from here and there. I mean, we're not suggesting that this is an inquiry into whether there was an intent to defraud the court or anything like that. I think what the doctrine looks to is the intentional inconsistency, and where a litigant makes an intentional inconsistency to gain an unfair advantage through the courts. This court recognized in New Hampshire that undermines the integrity of the court, and that is sort of consistent with an intent to mislead the court often. But we're not suggesting that a finding of actual bad faith is necessary. Or part of the analysis.
But are you suggesting that this finding of intentional misrepresentation is necessary? This goes to Justice Gorsuch's question again, and also to the Chief Justice's when he opened, but he said, in the end, judicial estoppel is about the integrity of the courts. And aren't there circumstances in which, even though you couldn't find that kind of intentionality on the part of the debtor or the part of somebody else making the representations, still the integrity of the courts is on the line?
So I don't think the court has to rule that out. I mean, I think the courts, just as frequently talk about how judicial estoppel doesn't apply in the case of inadvertence or mistake. And we think in that situation where a party, because of a mistake, hasn't intentionally adopted a particular position, that there is not the same kind of threat to the judiciary. But this court doesn't need to say here that judicial estoppel is never appropriate in any situation in which a party makes a mistake. I mean, we think it's an important factor. The court recognized it in New Hampshire. Other courts have universally recognized it, and it's particularly important and applicable in this unique context.
Thank you.
Justice Gorsuch?
Very briefly, Mr. Gar. I take your point that you don't need to have an intention to mislead the court. You say, though, an intention to pursue inconsistent positions is required. I just don't see that in New Hampshire either. I see you have to take inconsistent positions, but I'm not sure I see that you have to intentionally do so. Am I missing something there?
So I think in New Hampshire on page 750, it talked about prohibiting parties from deliberately changing positions according to the exigencies. I mean, the court cited lower court cases like Scarano, which talked about...
It does cite lower court cases, but when it actually lists the factors, it just says inconsistent positions and deriving an unfair advantage from them on page 750.
But then I think that... I'm sorry, Your Honor.
No, go ahead, please.
But then I think when the court later, in applying the factors, says that courts have resisted application in the instance of mistake.
Yes, inadvertence and mistake. That we know to be true. That New Hampshire definitely does say.
Right.
And I guess that leads me to this. Judicial estoppel is kind of an off-branch of equitable estoppel.
Because it's
and is a relatively
equity's all
new
about
invention
fairness.
dating to, well, new, dates to the mid-19th century. For law, I guess that's new sometimes. And we have exactly one opinion on the subject, New Hampshire. That's it. We haven't developed a law very much yet. And I wonder whether you would be content with the following ruling, and if not, why not? We've said inadvertence and mistake is not a basis for judicial estoppel. The Fifth Circuit
Trying to one-up each other
rule with one of its own, a bright line
You guys
rule
can share
that
me.
It's never inadvertence and mistake when there's a knowing omission and there's a motive. Would it be enough to simply say, we don't need a further gloss on inadvertence and mistake, this is an equitable doctrine, go back and do it again, looking at what we've said?
So that would be an improvement, Your Honor, but I think that what the court needs, what the Fifth Circuit needs guidance on is that you really have to take this holistic analysis in terms of whether or not there was a mistake.
Yes,
And
I'm giving you that.
Right.
I'm just simply saying their bright line rule on what does and does not qualify as inadvertence and mistake is not what we said in New Hampshire. Go back and try again. maybe applying state law, maybe taking cognizance of the bankruptcy context, all of these kinds of additional concerns, but a very short and succinct opinion saying, look at New Hampshire.
So I think that that would be fine. Obviously, the devil's in the details, Your Honor, but I think what's critical there
I don't
is
think
that
there would be many details.
that the upshot would be is that in this instance, if the courts conclude that a debtor's failure to update a form was simply an honest mistake, that it generally it would be inappropriate to apply judicial estoppel.
If it's
And
inadvertent
that's the
or
basis.
mistaken. Yeah.
Yes.
Okay, honest mistake. Okay, thank you.
Justice Kavanaugh?
Is there any difference between a knowing inconsistency and an intentional inconsistency? I'm not sure about your answer to that.
I don't think so, Your Honor, but the point that's critical here is that the court has to determine that when the debtor failed to update his form, he was knowingly or intentionally adopting the position that no cause of action exists. And
Knew or should
instead
have
of,
No daylight, just making sure.
well, I mean, look, in the law, there probably is.
Knew or should have known.
difference
It's like a
between
thing.
knowing,
I know.
willingness,
Hey,
intentional.
In this context, is there any daylight between a knowing inconsistency and an intentional inconsistency as you see it?
As a practical matter, I don't think there is. I
By the
will
way,
say that
Jackie,
the courts have talked about intentional
maybe
inconsistency. I mean, that's the language this
if you
court
can find your way over to the
piggybacked on
Well, I
stats.
think that
court
creates
cases.
confusion as Justice
and you want to
Gorsuch
read
was
in the
talking
background while they're
So,
talking,
I mean,
I
I
did
think
write
the
out
intent
in longhand
language is well
what I
taken.
said about
I mean, if this court believes that the knowing language is
bankruptcy.
more suited to the doctrine, I mean, I think that would lead to the same conclusion here, and that's what we're up here fighting for.
Thank you.
Thank you, Your Honor.
sort of explaining.
Justice Jackson?
So I'm noting that New Hampshire wasn't a bankruptcy case, and I'm thinking that maybe judicial estoppel is sort of a poor fit for this context, because even if there is an intentional omission, however we define that, the bankruptcy court has many, many tools, I think. This is
It's an
sort of
equity
what
court.
Justice Sotomayor was alluding to solve that problem when it comes to its attention, and to prevent the estate from getting this additional asset seems to harm the creditors in ways that I don't think are consistent with the way we understand bankruptcy. So, I mean, in addition to Justice Gorsuch's solution, I suppose one thing could be to think about whether judicial estoppel is really the right remedy here.
So, again, I'm not going to quarrel with anything that results in a conclusion that judicial estoppel doesn't apply. But what I think is important here is what the bankruptcy court has control of these proceedings, and its actions or inactions should be an important factor in determining whether or not judicial estoppel is.
Do you know if there's ever a world in which, is it after the bankruptcy closes, if this information comes to the bankruptcy court's attention, is there nothing that could be done at that point, or?
So it can be reopened.
It can be reopened. There's always an opportunity to take advantage of it.
And I'm not going to make my friend's argument. What I would say, though, is I think that the courts have assumed judicial estoppel is applied here because on the theory that the second court is being duped, so to speak, in the sense that there's inconsistent positions, and so it's a threat to the second court. But I think Your Honor's point is exactly right, that the bankruptcy context is unique and that there's an important role for the bankruptcy courts.
And the second
a lot of
court's
this can be resolved.
proceedings are sort of completely independent, right? I mean,
Yes.
they're arising out of facts that have nothing to do with the bankruptcy.
Exactly, and that underscores the windfall that the defendant is getting. The defendant in the second proceeding has no connection to the bankruptcy, and yet the defendant walks away scot-free.
Thank you.
And that's not equitable in any sense.
Thank you, counsel.
Thank you, Your Honor.
Oh, okay. So, yeah, if you guys didn't see the morning report this morning, basically,
Mr. Chief Justice, and may it please the court. Oops, I
the
spilled the water.
human being
That's a
in a
first.
bankruptcy doesn't
Judicial
actually
estoppel
control
should
any of
apply
their
only
stuff.
if the balance of equities supports it. In New Hampshire
The
versus
creditors
Maine,
really kind of
this
own
court
it
described
in that time
factors
period until the
relevant to
end
that
of the Chapter
balance.
13. So that's
Those
what I mean by
factors
interest of
include
creditors.
whether a
They-
party derived
the trustee
an
controls
unfair
it
advantage from
on
the
behalf
prior
of the creditors.
position, whether that position was the product of inadvertence, and whether judicial
hard to
estoppel is
explain quickly.
consistent with broader public interests. Here, the Fifth Circuit made two errors. One is the error petitioner has focused on this morning. The Fifth Circuit reduced inadvertence to just two considerations, thereby failing to consider the totality of the relevant evidence, including evidence that petitioner reasonably believed that he had no duty to disclose his tort claim while a damages award was still a long ways off. But the other error is, in our view, even more fundamental. The Fifth Circuit effectively reduced the
Actually,
entire
Jackie, it's a
balance of
pretty good
equities
situation.
to a single factor
You get to
inadvertence,
keep all your stuff
thereby ignoring the interest of
and use
innocent
it
creditors
for
and the
3
bankruptcy
years
court's ability
and just
to
pay a little
undo
fraction of it
any
off.
unfair advantage. Therefore, the decision below should be vacated and the case remanded. I welcome the court's questions.
Mr. Liu, I'd like you to take a step back to New Hampshire. New Hampshire was
13,
quite a
yeah.
different case from this.
And at the end, you still get to keep all your stuff.
Involved litigation
But you have to
between
pay it all,
Maine,
and then at the
and
end,
New
it
Hampshire
becomes
over
yours again. But
boundaries.
during the time period,
In 2 earlier
not yours.
cases, New
use
Hampshire
it,
had
but it's not
accepted
yours.
that the middle of the river was the boundary. And in the subsequent litigation, it changed and argued that the boundary was to the Maine shore. And what the court said, in Justice Ginsburg's opinion, was that you could not, to your advantage, change positions like that, and hence judicial estoppel. How does that fact pattern allow us to decide this case based on New Hampshire?
Well, you're right that the specific context of New Hampshire is far different from a bankruptcy case, whereas some justices have already mentioned the 2 proceedings, the bankruptcy case.
Well, I'm not as interested in the bankruptcy case. I'm interested in the fact that the litigation was between the same parties, between New Hampshire and Maine. Here, that you do not have that mutuality.
That's right. And I think what this points up is that for judicial estoppel to apply, the balance of equities has to support it. And in New Hampshire versus Maine, I think it was important to the balance of equities that you had 2 co-equal sovereigns that had been involved in the same litigation many years prior. That's part of the balance of equities. Our submission here is a court shouldn't blind itself to the balance of equities in this context either. I think what New Hampshire versus Maine teaches is there are 2 kind of essential elements of judicial estoppel. Those are the first 2 factors. You got to have inconsistent statements, and you got to have the first statement relied upon by the court. But beyond that, and this is on pages 750 to 756 of the court's opinion, it's a balance of equities analysis. You look to see if one party derived an unfair advantage. You look to see if the prior position was the product of inadvertence. You look at the broader public interest, including the fact that these were 2 co-equal sovereigns that were involved in the same case earlier, and you ask, after considering the entire balance of equities, whether judicial estoppel is appropriate. I think what's really wrong about the Fifth Circuit's decision in this case is if you look at PEDAP 9A, it reduced that entire balance to just 1 factor, which is inadvertence. And then beyond that, compounding that error, it turned inadvertence into just 2 considerations, knowledge of the facts and potential motive, which is not a totality analysis of even the 1 factor the Fifth Circuit thought it should consider.
Mr. Liu,
Frog,
I
I
guess I'm
nodded,
not
but
sure
I
I
was agreeing with
understand
you,
how
yes.
what you're saying
Sorta.
right now fits with this footnote that you wrote. This is page 24 in your brief, footnote 2, where you say we shouldn't talk about whether inadvertence always precludes judicial estoppel. And I hear you saying now we should talk about that. We should say
Jackie.
inadvertence is just 1
713
factor.
here, individual.
It doesn't always preclude judicial estoppel. Am I wrong about that there's a shift here?
I wouldn't say it's a shift in this sense, and I think there are two analytical things at issue. One question is what goes on the balance, and we think that is an important question the court should address. What goes on the balance is not just inadvertence, but also unfair advantage, other interests, et cetera. That's all what goes on the balance. I think there is a separate analytical question about how those various factors relate to each other. And what we mean by footnote 2 is this court doesn't need to decide whether one factor, if it exists, is necessarily going to trump the other factors. We think it's enough for this court to basically reiterate what it said in New Hampshire versus Maine, which is the balance of equities isn't just one factor, it's all these factors. The court said it was non-exhaustive.
But do you agree with this, that even if you had all the intent in the world, it doesn't necessarily get you judicial estoppel? And conversely, even if there was complete inadvertence, it doesn't necessarily preclude judicial estoppel?
That is the government's position. I think that's that second bucket of analysis. The court doesn't need to go that far. I think the court can just say, look, if you're a lower court, you should be looking at all the factors. It may well be that one factor turns out to be dispositive. After you've seen a bunch of cases, maybe you can reach that conclusion. But at this part of the analysis, you should at least have in full view all the relevant factors.
And is the idea behind this that everything needs to be filtered through the principal purpose of judicial estoppel, which is protecting the integrity of the courts, and that this question of intentionality may coincide with that principal purpose, but in certain cases may not? Correct.
We think certainly when a party has deliberately taken a prior position, as opposed to having taken it by inadvertence, it certainly heightens the impression that I think judicial estoppel is trying to avoid. And that impression is the impression that courts are just arbitrarily giving a party whatever it says it wants. But conversely, there may be cases where the first party gets a tremendous advantage, even though it took that position inadvertently, and it doesn't make sense, it just wouldn't be fair to allow that party to obtain a further advantage in the second proceeding.
Mr. Liu, I take your point that inadvertence and mistake may not automatically defeat judicial estoppel. But I'm also not sure we need to get into what all the factors are or even talk about a holistic analysis, given, as Justice Thomas pointed out, New Hampshire was, really could have been an equitable estoppel case, forget about judicial estoppel. And the bankruptcy context is different, and we have an Erie problem, and all these. Why not just simply say the factor of inadvertence and mistake, whatever it means, doesn't mean what the Fifth Circuit said it meant. Goodbye.
That is a sufficient ground for vacating and remanding.
And you have no problem with that?
We have no problem with that. We just wanted the court to be aware when it's considering the scope of inadvertence that it may not be the be-all, end-all of the analysis, that you might not necessarily hang everything in the case on whether it's inadvertent or not.
We don't even need to take a view on that, it seems to me. Maybe some future case there'd be a reason to make it a bright line rule, maybe not, as you say. We don't have to take a position in this case on that, do we?
That's right. And really our submission is you don't need to move the lines you drew in New Hampshire versus Maine an inch. New Hampshire versus Maine said inadvertence, it may be appropriate to resist application of judicial estoppel if the party's prior position was the product of inadvertence. We're happy with that statement of what the law is.
Thank you.
We dispute the way inadvertence was defined here.
Well, I mean, New Hampshire against Maine, it's featured prominently because it's the only thing. I wonder if saying anything about it, I mean, it's two sovereign states against each other and the boundaries. You know, I'm not sure that we should try to bring it into play any more than is necessary.
I don't really quibble with that at all. I read New Hampshire versus Maine as setting forth pretty high-level principles. I mean, the principles I understand that decision to set forth are the balance of equities matters, and the list of equities is kind of non-exhaustive, and inadvertence may be one of those factors. I think at that level, there's nothing wrong with taking those principles and articulating them here. I agree, once you get into how those principles cash out, you may not be in a situation where New Hampshire versus Maine really speaks to that.
Thank you, counsel. Justice Thomas? Justice Alito?
I know I will have a chance to speak to Justice Gorsuch later, but you answered him.
Jack,
I
yeah,
don't know
I don't
what
know
you
why it's
think
taking me so long, but I'm writing up
simply
a thing for
saying
you.
they were wrong about inadvertence would get us. Because you
hard to
came up
think
here
and
and said there
listen
were
at the same
two
time.
fundamental errors, and that, and I thought in describing the errors, both times you said the court failed to take into account totality of the circumstances. So it wasn't just merely their failure to address inadvertence properly. They failed to do the holistic evaluation of what was the prejudice to the parties from that inadvertence, even if it was deliberate. It could still, you've said all these other things, so I'm not sure.
Well, we would certainly be more satisfied with an opinion that went further and said inadvertence is not the only factor. We think that just follows pretty directly from New Hampshire versus Maine. To give one stark example.
Yes, Doughboy, this is Phil
Hampshire
Keathley.
But why did you say yes to an
Oh,
opinion that
well-
basically brings us back here? Because I can see the Fifth Circuit saying exactly what it said below. If you know
That's
you
for
didn't
Jackie.
say it, it's intentional, it's not inadvertence. So they've already answered that question.
Yeah, no, so
And so I'm not sure.
I don't think this is getting to the error I think this court needs to correct, because it is core to the dispute between the parties, which is this is the correct definition in our view of inadvertence versus non-inadvertence. We think in all cases the relevant question is, did the party deliberately take the prior position? In other words, did the party deliberately choose position X?
So does it come down to the Fifth Circuit now coming back to us and saying he told his attorney, but the attorney didn't tell the court, and you're responsible for your attorney's errors?
So
Which is what we usually say.
We do think the attorney is responsible. The attorney's conduct does bind the client.
And so that's what the Fifth Circuit basically said here, that the attorney knew, the attorney didn't say it. So we're back to the circle.
Well, here are two errors I think the Fifth Circuit made just as to inadvertence. One is it deemed irrelevant, and this is on PEDAP 13A, any evidence regarding the attorney's knowledge of whether the duty to disclose applied in this case. That is a bucket of relevant evidence, relevant and mainly objective evidence in our view, that the Fifth Circuit didn't consider. And the second error is, even with respect to its analysis of the potential motive that Justice Alito brought up, the Fifth Circuit's analysis was incomplete. I mean, the record suggests many reasons why there was no modification of the plan when this tort claim was ultimately disclosed. The fact is, no matter when you disclosed it, it would have been years before this claim would have become an award of damages.
In one word, I'd do a simple opinion that says you have to look at the totality of the circumstances, and you can't reduce it to the three factors that you mentioned alone.
That
would be my opinion.
That's right. And the Fifth Circuit ignored evidence relevant to the knowledge of the duty
still have
and
one more
ignored
case, Dee.
evidence pertaining to the potential motive prong that the
All
Fifth
right,
Circuit
thank you, Judge.
did consider.
Justice Kane? Justice Gorsuch?
I don't know where we are. And we still have one more lawyer.
Justice Jackson? Thank you, counsel. Mr. Jay?
Mr. Chief Justice, and may it please the court. The question the court
known
agreed to
Otro
decide in
next.
this case is not about whether there was a clear inconsistency between the representations, but about whether proof of bad faith is required before judicial estoppel can apply, and the answer should be no. Where the same litigant seeks to win a second victory on grounds that are clearly inconsistent with the grounds on which he won the first victory, that undermines the integrity of the judicial
write that
process.
down.
And it is not necessary to also prove that as Mr. Liu just said, that litigant intended to switch positions all along. I'd like to make basically three basic points, one about precedent, one about practicalities, and one about bankruptcy. The first is that there are multiple cases, not just New Hampshire, also the 19th century cases that New Hampshire addressed. I don't think petitioner's rule can explain any of them. One key thing that New Hampshire says is that mistake or inadvertence looks at time one, not time two. And I think there's been a lot of inconsistency with the other side's presentation this morning about whether they look at time one or time two. Second, in practice, as the district court noted, basically every litigant facing judicial estoppel claims his original position was a mistake. Under the other side's rule, just a declaration claiming a lack of legal understanding or that the attorney gave bad advice would be enough for a trial. And third, although we are not urging a special rule for bankruptcy cases, as the other side is, we think that our rule better fits the bankruptcy context anyway.
Okay.
Petitioner's rule would undermine the full disclosure of assets on which the bankruptcy bargain depends. A doctrine, as Judge Easterbrook puts it, that encourages debtors to be truthful in their bankruptcy filings will assist creditors in the long run. That is why our rule does not deprive creditors of recoveries that they would otherwise be able to get. District courts might well exercise their discretion at the margin in favor of less culpable litigants, but there's no reason to make bad faith a prerequisite. I welcome the court's questions.
Is there any difference between your rule and the Fifth Circuit's rule?
Not in practice, and certainly not in this case. The one, if I were writing the rule for all circumstances, I would say that the question of benefit, which the Fifth Circuit describes as part of the inadvertence or mistake inquiry, I think New Hampshire would put that earlier in the analysis. In the core, New Hampshire's core three factors are clear inconsistency, accepted by the tribunal, and getting some benefit that would be inequitable for you to keep. And I think that we would put the sort of the financial aspect of the benefit that the litigant gains from the bankruptcy in that bucket instead. I don't think that's an analytical point. I don't think it makes any difference in this case. So we certainly agree with the Fifth Circuit that the question is not whether the litigant himself got bad legal advice or was subjectively aware of the legal duty as opposed to the facts.
New Hampshire also considered the detriment to the party before the court in the subsequent litigation. What is the detriment to your client?
So in New Hampshire, the court said or, in other words, that it said either benefit to the party that took the position or detriment to the adversary. And I think New Hampshire is unusual, and your question to my friend earlier about mutuality gets to this. It is actually unusual for judicial estoppel to come up in second piece of litigation involving the same parties, precisely because if it's the same party, they're well positioned to call the person out for switching positions. In the Philadelphia Wilmington Railroad case that New Hampshire discussed, it's been settled since the 1850s that this is primarily a doctrine about defending the court's integrity, and for that reason, mutuality is not required.
How would you respond to petitioner's argument that this is a windfall for your client?
I think it's just the same point, that the way in which courts' integrity is preserved through the use of this doctrine is that the litigant against whom the inconsistent representation is being made points it out to the court. And so in that sense, because mutuality isn't required, it is that litigant standing in for the court and pointing out that the court is about to be misled by the common litigant who took the clearly inconsistent position in the prior action. So I understand the windfall point, but I think that's just, you might say the same thing about res judicata collateral estoppel, that the system cares more about locking down the first determination and preventing it from being relitigated rather than saying, well, the correct answer would be to side against the second litigant rather than the first.
Well, but it's not really just relitigation. It's a new person jumping onto the scene. It does seem, in terms of the court's integrity, it does seem a little much that the one person who's getting off is the one whose truck hit the other guy, right? I mean, it's a lot easier to explain why that's a bad result than simply the idea that, there was something else that went on that the court didn't know about, and now you're going to change the natural sense of the propriety of the result by saying the one person who we know inflicted harm, according to the allegations, of course, gets off scot-free.
So I think that's a consequence, Your Honor, of the fact that if this comes up, it comes up at a time when it's too late to reopen the first proceeding. And this goes to a question that Justice Sotomayor asked, that one of the elements of judicial estoppel is that the first proceeding has already resulted in some benefit to the common litigant. And so every court of appeals that has applied New Hampshire to the bankruptcy context has agreed with the basic proposition in this case, although I think it's one that Mr. Garr seems to be disagreeing with, that a representation to the bankruptcy court that there is no cause of action is inconsistent with asserting in a subsequent action that there is a cause of action, just like asserting ownership of a piece of property or a different legal interest.
Be sent back down.
Asserting that you don't own that property in one action is inconsistent with trying to invoke the ownership right in a second action.
Yes, it's inconsistent, but what is the advantage that is gained from that in this situation?
So the advantage in a bankruptcy in which the debtor has an incentive to minimize assets is the ability to convince the bankruptcy court that, so this is a Chapter 13 case, that taking this as an example, that a Chapter 13 would be just as much in the creditor's interest as a Chapter 7, which is always the...
I understand, but the bankruptcy court could convert the proceeding if that information is brought to their attention. The creditors apparently in this case, for whatever reason, said, we don't care. I don't understand what the advantage is that is being apparently at the heart of your concern that judicial integrity is threatened or something in this situation.
The advantage that a litigant gets is convincing the bankruptcy court to confirm the Chapter 13 plan.
Not a litigant, this litigant. In other words, in these circumstances, because as others have pointed out, we're talking about a totality of the circumstances, equitable assessment of whether judicial estoppel should be applied.
Right, and if you want me to talk about the facts of this case, so in this case, at the time that the debtor had the cause of action, the debtor also fell behind on payments and had to submit additional amendments to the or modifications to the Chapter 13 plan. And the trustee initially objected to the first of those amendments and said, this amended plan doesn't leave unsecured creditors as well off as a Chapter 7.
And once the information was brought to their attention, no one sought interest, no one thought the plan should change in any way.
So respectfully, Your Honor, look, that's a distinct point, and I'm happy to address that because this was brought to the bankruptcy court's attention such as it was. And if you look at page 203, you'll see that the debtors didn't actually disclose any valuation for this claim. They didn't change the sum total of their assets at all. They just listed, they mentioned the claim and said unknown. This, of course, was well into the payment plan. It's after the new confirmation had been granted. And at that point, I think it's not surprising that creditors who were receiving this stream of payments and weren't really told anything about this cause of action didn't affirmatively seek reopening of the
I guess
bankruptcy.
My question is it fair to just assume or presume that by not having this information, an advantage has been obtained such that it makes sense and is equitable to preclude the debtor from accessing or having this asset, which could, in some situations, actually go into the estate and be a part of the entire bankruptcy? It just seems very harsh.
So I'm happy to answer the question, and I just let me note by way of preface that whether there has been an advantage gained, I think, as this is much of my colloquy with Justice Thomas earlier, I think that's a different question than the one on which the court granted cert. I mean,
well, we certainly didn't grant cert on the bad faith. You said that at your original statement, and I took issue with it. The question the court granted cert on, you said, was whether proof of bad faith is required.
Right.
If we look at the actual question presented, it's whether the Fifth Circuit's formulation, which is requiring potential motive for disclosure, was correct.
Right, but if you look at the last sentence of the question presented, right, it says that the reason that the Fifth Circuit is wrong is that it doesn't require proof of bad faith, and that is the fundamental submission that we're making to the court, that inadvertence or mistake, as an exception to the judicial estoppel doctrine, does not connote proof of bad faith. I mean, it may...
Mr. J, if we're talking about protecting the integrity of the courts, I just want to clarify a factual point. Am I correct that the bankruptcy court declined to sanction?
No party asked for sanctions, Your Honor, so that...
The bankruptcy court knew because this was brought, let's see, it's my understanding that the bankruptcy court knew about this because he ultimately did go back to the bankruptcy court and make the court aware. Am I right about that?
There's an amended schedule that, as I was saying to Justice Jackson, doesn't disclose the amounts, but states that there is a claim, for the first time, that there is a claim in the answer to question 33 on the schedule. That's
Maybe
after the confirmation.
And maybe this goes to Justice Sotomayor's point and Justice Jackson's point to your friend on the other side. Why isn't the bankruptcy in this context, why wouldn't we expect the bankruptcy court to be the one to police this?
I think that no one asked the bankruptcy court to take any action, and it may well be that, as I was saying to Justice Jackson, that the creditors concluded that this late in the payment plan, it wasn't worth the candle to do so. And the bankruptcy court, and this to the point that Justice Jackson asked my friend about, the bankruptcy court may have tools that it can use in bankruptcy in the sense of denying a discharge or denying access to Chapter 13 and forcing the case to be converted to Chapter 7, or even referring to criminal prosecution. But all of those things go to the bankruptcy itself rather than to the consistency of the representations between the bankruptcy and a subsequent proceeding.
If we might zoom out just for a second, judicial estoppel is an off-branch of equitable estoppel. Equitable estoppel requires mutuality. Our judicial estoppel one case had mutuality where a benefit gained by one party did cause a detriment to the other. Could have been an equitable estoppel case. This is where we don't have mutuality. And if judicial estoppel is about protecting the integrity of the courts, I get the concern on the one side that there's perhaps a misrepresentation to the bankruptcy court, subject to all the caveats we've discussed. But the courts also have a duty, and they're open to claims of personal injury. And to give your client a windfall would also seem to have some impact, again, zooming out, on the integrity of the judicial process and its accessibility. No?
I don't think so, Your Honor, any more than issue preclusion does, which is the court's.
No, I understand we have non-mutual issue preclusion, right. and you alluded to those, but those doctrines are, again, new and riddled with exceptions when it comes to non-mutual collateral estoppel and the like. And it does seem to me like often we don't do it when it's just not fair. And here, how about, again, if we're concerned about the integrity of the judicial process, why isn't one consideration that your client would just get a plain old windfall?
So the non-mutuality goes at least back to the Philadelphia-Wilmington Railroad case in the 1850s, which discussed in New Hampshire, right? So I resist the premise that it is as new as, for example, non-mutual issue preclusion.
Okay, I take the point.
Right, and the significance that we take from the fact that, as you said, judicial estoppel grows out of equitable estoppel is that equitable estoppel likewise doesn't have this type of state of mind requirement. It focuses on
put aside the state of mind requirement. Put that aside. That's not relevant to my question.
But I think that the reason that there is no state of mind requirement for equitable estoppel or judicial estoppel is that both doctrines focus on the effect. Equitable estoppel focuses on the effect to one litigant. Judicial estoppel focuses on the effects on the judicial system.
Yes, and my question is, one of the effects on the judicial system here is we're closing the courthouse doors to a good claim and allowing one party who's engaged in tortious conduct to walk away scot-free.
The premise of your question, Your Honor, that it is a good claim is that—
Let's assume, I know you resist that, but let's just assume that.
I'm not resisting it for the usual, lawyers don't concede anything reasons. I'm resisting it because it's the very premise of judicial estoppel that we don't look past, once the first case is over, we don't look past the accuracy of the representation in the first case. That's the point, right? The whole point of the representation in the first case, whether it's New Hampshire or this bankruptcy case or any of the other judicial estoppel cases, is the representation that, in this case, I don't have an asset of this nature.
Thank you.
Right. So I think that Mr. Garr, in his presentation, brought this, back to the sort of the mantra of a failure to update a form, and I do want to resist that characterization because, again, first the court didn't grant cert on the clear inconsistency point. There's no disagreement in the courts of appeals that where there's a representation that a cause of action doesn't exist, that's inconsistent with asserting it. And in this case, there's no assertion of a factual lack of knowledge. In fact, the facts show that all the facts were known. There's also no dispute about the obligation to disclose. And this gets to a question I think that Justice Alito asked my friend earlier, that where there is a duty to disclose, that failing to make a disclosure is a representation to the courts that there is nothing to disclose. So because those aren't the questions before the court, all I think that the other side is left with is saying that they resist the idea that either the attorney knew of the legal obligation, which in that bankruptcy court is well established, it's been established for at least a decade, or that the attorney failed to give advice on that to the debtor. And on tying together all of the questions about what you might say in an opinion, we would urge you to say in an opinion that that attorneys' representations matter, that a litigant can't escape judicial estoppel by saying, although my attorney made this representation to the court in the first action, that's a mistake because I didn't understand the consequences of the choice that my attorney was making. That's fundamentally inconsistent with the notion of mistake as this court has used it for well over a century. I think this is well fleshed out in the German versus Carlisle-McNally decision that we cite in our papers. But that cites precedent going well back to Justice Story, construing a statute involving mistake or error. Legal mistakes aren't that kind of mistake. And that type of error is not what the judicial estoppel doctrine or the inadvertence or mistake exception to it are getting at. And I think Justice Jackson had the hypothetical in the top half of the argument about the asset being concealed from the divorce. And I think that the point that I wanted to make from that is that how is that example going to come to light? And how are these causes of action that are not disclosed in bankruptcy? And that if disclosed, the bankruptcy court could make its determination about whether they should have been disclosed sooner and what the consequences should be. How are they going to come to light if there is no incentive to litigate the fact that they didn't come to light sooner? So as the lower courts have recognized, that apply our rule, not just the Fifth Circuit, but also others.
But why does the incentive have to come from the threat of not allowing you to pursue the claim? I mean, this is the point that many have pointed to or made with respect to all the tools the bankruptcy court has to sanction an intentional omission of that nature.
But the tools to sanction all presuppose that someone's going to find out about the concealed claim. And the tools are not useful if the assets don't come to light.
Yeah, but you need to find out about the concealed claim in order for the claim to be extinguished. I mean, that's a necessary condition for anything to happen. The question is why, once we find out about it, the remedy is to say you cannot pursue that claim as opposed to some other solution.
I mean, I think the reason is the clear inconsistency. I mean, and this doesn't just come up in the context of the good claim that we're talking about. I mean, this comes up in all types of bankruptcy actions in which party makes a solemn representation to the bankruptcy court about the amount of property that they have, and they subsequently turn around and make representations to another court that are flatly inconsistent with that.
I understand, but the equivalent would be that once that happens, somehow the bankruptcy court could divest the person of that property, which is not the answer, right? The answer is they adjust the bankruptcy proceeding to sanction them appropriately.
But that's just it, Justice Jackson. I think that once the plan is confirmed and the debtor gets the discharge, I don't think that my friend on the other side is correct to say that the bankruptcy court always has the option to say, oh, I'm going to take some further action. In a Chapter 13 plan, if the creditors have been paid off, then the creditors have been paid off.
Thanks for coming in.
And a Chapter 13 plan is time limited. The bankruptcy court, I think, doesn't have the free hand that your question is positive.
And should that factor in then to whether or not judicial estoppel is appropriate? Why couldn't, in the totality of the circumstances, maybe in that situation you would have judicial estoppel?
So I mean, I think our I resist giving a bankruptcy-specific answer, but I'm happy to give an answer for that question. In every judicial estoppel case, rather, the question is, what is the benefit that the common litigant, between the two actions, has gotten from the first action?
Near the end,
and if
I'm
it's
not
raised
too-
early enough that the litigant can surrender the benefit, then there isn't going to be judicial estoppel. I think that's just baked right into the doctrine. You don't need a bankruptcy-specific rule to say that, because I think that's part of judicial estoppel, just like the clarity, like the clearness, how clear the inconsistency between the representations is also baked into the judicial estoppel doctrine. And when there's doubt about whether a pro se litigant or something like that has made such a representation, then the existing judicial estoppel doctrine can deal with that.
Thank you.
Unless the court has any further questions?
Thomas?
Yep.
Thank you, counsel.
Who is William? Have we? I'm going to ask.
Rebuttal, Mr. Gar?
Fashawn, do we know
Mr. Chief
this
Justice.
guy? He's
We
pretty
would
good.
welcome any ruling setting aside the Fifth Circuit rule in this case, but we do think it's important for the court to say that a holistic analysis should be undertaken into intent, because I do think that it's likely this case will end up
Actually,
right
all
back
been pretty good today.
before this court, as Justice Sotomayor indicated. And then we would urge the court to let the lower courts sort out the particular facts and circumstances, in this case, under the holistic analysis. As
do we
to the
know that
question
lawyer, that
presented,
last
the
lawyer?
question presented and the whole petition is directed right at the Fifth Circuit's rule here. There's absolutely nothing that prevents this court from considering that question, resolving the circuit split, and the court should do so. Petitioner disclosed his claim with more than a year left on the bankruptcy plan. In this case, the bankruptcy court could have objected if it thought anything was awry, and any creditor could have come forward and objected if it thought it was entitled to anything more, but no one did. And last, I would just say on the windfall point, no doctrine of equity would allow the tortfeasor in this case to walk away scot-free if the debtor here simply made an honest mistake in failing to update
All these little lawyers are pretty
the
good.
Fifth Circuit's decision should be reversed and the case remanded. Thank you.
Thank you, counsel. The case is submitted.
All right, one down. Now, so yeah, I guess whatever. Yeah, like I just said to the guys over on the tubes, I could stop and give a long lecture on bankruptcy, and it is so complicated. The idea about the shell, which I put in my thing this morning, is probably one of the most complicated ideas. Just the idea that when you file for bankruptcy, you leave behind this fake human being. You go for a walk and become free of this thing that owns all of your stuff and all of your debts from then on. And we have to protect that stuff. We have to protect the creditors, because if we don't, then they will stop extending credit. So it is important to make sure that their interests are protected in some way. But you walk away, that stuff stays behind. And in Chapter 7, that's the end of it. The trustee takes it over, sells your stuff, and redistributes whatever comes out of it, which is almost always nothing. It's usually like a couple of old T-shirts, which we really just give back to you, and nothing else. You have $7 in your bank account. You get to keep a certain amount by state law usually, so it's like up to several $1,000s you get to keep. If it's secured like a house, that's a whole different agreement, because technically the mortgage company owns that, so we don't even talk about that. All that stuff. But in Chapter 13, it's a different agreement where we agreed that for 5 years you're going to make a monthly payment. We figure out what that amount's going to be based on how much money you have coming in and all that, and make sure you can eat. And the estate's going to hold your stuff. The trustee's going to take care of is going to own your stuff for that 3 to 5 years. But you still get to use it as long as you make your payments. And at the end, you get it all back.
Otro Lado.
But only if you
Mr.
make all your
Suri.
payments.
Mr. Chief Justice, and may it please the court, respondent's position is that when Congress said arrives in the United States, it meant stopped outside the United States. That theory is wrong for the simple reason that it defies the statutory text. You can't arrive in the United States while you're still standing in Mexico. That should be the end of this case.
This is kind of silly.
But even if you see some ambiguity in the text, the court's decision in Sale should clinch the case for us. In Sale, this court determined that the protections of the Refugee Convention and the withholding of deportation statute do not extend to aliens outside the United States.
Yeah.
And
Not touching
further,
you.
that it is
Not touching
entirely
you.
lawful for the executive branch to prevent aliens from reaching U.S. soil and claiming those protections. If Congress meant to depart from that territorial approach when it adopted the statute here just 3 years after Sale, it would have said so. It didn't. This court should therefore uphold the metering policy and reverse the Ninth Circuit's
The rule
judgment.
is they have to process somebody for asylum when they
treaty
arrive
obligations that
in
are
the United
implicated,
States. And these guys are
by
saying,
either
well,
the metering
if you're 10 feet away,
policy
you haven't
or
arrived
the,
in.
issues here.
No, there are not.
You've
Justice
arrived
Thomas.
at the United
Respondents
States.
rely primarily here on the Refugee Convention
Is
and
it
the
skipping?
protocol.
Oh, weird. I don't
But
know.
there are two reasons for which those don't apply in this case, and those aren't violated by metering. The first is, as this court held in Sale, those provisions simply don't apply extraterritorially. They apply to the return of someone from the United States, not
audio
to,
skipping or just the
in
video?
Sale, the return of Haitian refugees who were interdicted in international waters. And secondly, even where that convention does apply, what it prohibits is returning someone to a foreign country. Metering doesn't return anyone to Haiti or Guatemala or wherever the person might be coming from. It just says you can't set foot in the United States.
I'm not sure that I understand how you can say that we're not violating our treaty obligations with your reading, and why Sale, you think Sale protects you. Sale very clearly says that U.S. asylum and withholding protections apply to those who reside in or have arrived at the border of the United States. It also explained that refoulement means a defensive act of resistance or exclusion at the border, not merely returning a person to a country. Now, the Refugee Act was passed in response to the MS St. Louis situation, which was a ship in 1939 carrying over 900 Jewish refugees that landed in Cuba. The refugees weren't permitted to unload themselves. It then came to the coast of Florida, and the U.S. wouldn't let it dock at all right, and turned it back. And it did the same in Canada. Canada wouldn't let it dock. So the Refugee Act was passed to ensure that people who arrived at a border and knocked on the door, because that's what you're saying, these are people who come to the line. There's an agent standing at the line that's open to everybody else except refugees, correct? They're letting in workers with permits to come into work. They're letting everybody else in, but they're not permitting the people who come to the line, to the door, and knock on it, who want to claim refugee status. You're saying we're not going to inspect you. How does that not violate the Refugee Treaty Act or the spirit of the St. Louis UN Convention?
To start with the statute doesn't say arrive at the door.
No,
arrive
but
at
it
the
says
border.
arriving in the U.S. in various provisions. The inspection provisions says all aliens who are applicants for admission or otherwise seeking admission or readmission or transit through the U.S. shall be inspected by immigration officers. So various provisions of 1125 also speak about aliens arriving. Someone on a plane arriving to land in LaGuardia may not have put their foot on U.S. land, but they've arrived in the United States. They're arriving. They're knocking on the door.
Again, the statute that is specifically at issue here says arrives in the
So
United States.
if I believe that your reading violates the UN Convention, then what you're telling me is that Congress, when it passed this language in 1996, intended to reject its treaty obligations.
No, I'm telling you.
Without conversation about it. And a House report that basically said, there is no evidence that Congress, in fact, told us intended to make that provision. The House report stated that the new version of 1158 applies, quote, to any alien who is physically present in the United States or at the border of the United States. That was the language of the House report.
Not the language of the statute. The statute says in the United States.
But don't we read
not.
statutes in their context?
You read statutes according to their text, and there's no ambiguity.
No, you start with the text and context, correct?
Mr. Suri, the text has to make sense. And what is a little concerning to me about your reading of the statute is the practical implications insofar as it suggests that a Congress that was authorizing asylum would be requiring people to break the law in order to obtain it. So imagine a polite asylum seeker who wants to do everything by the book. He approaches the border, but does not cross, precisely because the law says you are not supposed to enter the United States without authority. Why on earth would Congress have intended or meant for his asylum request to be discarded, not taken seriously, not entertained, but someone who manages to enter the United States unlawfully, when the law says you're not supposed to do it, and requests asylum, gets their application entertained? That doesn't seem to me to make any sense, that if we're trying to think about what arriving in means, surely Congress was contemplating that a person would be coming to the United States, would be doing so with an intent to comply with the law that says you're not supposed to enter, and thereby asking for entry.
There are two reasons for which that makes sense.
Yes, Jordan.
First is that we have a separate refugee admission statute, Section 1157, that protects aliens outside the United States. So it makes perfect sense for Congress to say, if you're in the United States, you go to the asylum route, and if you're outside the United States, you go to the refugee
Yes, but I'm trying
route.
to understand the rationality of your interpretation of arriving in. You are suggesting that arriving in means the person who is literally standing on the U.S. side of the border, as opposed to the person who approaches the U.S. side of the border. And I don't understand why Congress would make that distinction.
Duh. Okay.
The second reason
Good.
that
Thank
Congress would
goodness.
have made that distinction, apart from the fact that the person in Mexico already has this other statute, the refugee statute, that he could turn to.
No. That's
is
not
that,
what that's for.
The problem of the
That's for
world's
people in-
refugees is not solely the United States' burden to bear. It's a shared responsibility of nations throughout the world.
No, I understand, but think about the statute at issue. It says arriving in. It first of all distinguishes physically inside, right? And it says arriving in, and it gives those people the ability to ask for asylum. And the way that your reading plays out, a person who is coming to, arriving in, approaching the United States can't make that ask, but they have to somehow violate the law by entering the United States in order to make that ask.
If I might complete the answer, Congress could reasonably determine that if a refugee is in Mexico, then the Mexican government is primarily responsible for processing his claim. Once the refugee is in the United States, whether legally or illegally, then the United States has greater responsibility toward.
I guess I don't understand how that's responsive. Can I just finish? I don't understand how that's responsive to my point.
Well,
which
he's
is the
also
person who is
forgetting that there are
in
two words here,
United
not just
States
arriving in, but also
asking for
present in.
permission
There are
to
two
enter
options here.
is
So there's
not
present in
necessarily
and arriving
in
in are
Mexico
both
in a way that
options. So they
implicates
wouldn't
all the
include both
concerns that you're talking
if they
about.
weren't supposed to
Yes,
mean
he's
two different
physically
things.
standing in Mexico, but imagine a person who has a placard on their body as they approach the border that says, you know, I would like entry, I'm being persecuted in Mexico. your suggestion that the United States would say, unless you
Hey,
can figure out a
awesome,
way
Robin.
to illegally cross, we're not going to entertain that claim, seems very peculiar.
It seems to me that the premise of the question is that there is something improper about blocking someone from completing the arrival.
The premise of the question is that arriving in has to mean something. And to suggest that it means that you have to actually illegally cross doesn't make sense.
There are other penalties that apply to people who illegally cross. It's a crime to
No.
illegally cross into
That's
the
not what
United
you said.
States. And the fact that someone has illegally crossed into the United States
No.
can be taken into
No.
account when the person is making the asylum application.
Precisely.
I'm sorry, please. Counsel, the statutory language, is it arriving in or is it arrives in?
It arrives in.
Okay, thank you.
Mr. Suri, if
Justice Kagan?
I don't think you had much of a chance to answer the part of Justice Sotomayor's question, which I am interested in,
Yeah.
about
You're
the
right.
treaty
You're
obligations,
right. This is a
and
tough
particularly
argument to
how the
make.
treaty obligations should or should not be interpreted in light of the St. Louis incident that gave rise to the treaty.
The treaty was a compromise between the interest in protecting refugees and the interest in protecting national sovereignty. And the compromise that was reached was, we're not going to require nations to admit anyone into the country, but we're going to forbid sending people back to other countries once they have already entered that country. And here, the treaty doesn't apply for two reasons. One, the individuals at issue haven't entered the United States. And two, they're not being sent back to any foreign country. They're just being denied admission to the United States. I would also note that even on any interpretation of the statute, the St. Louis situation wouldn't be covered, because there's a parenthetical in the statute that talks about people interdicted in United States or international waters, and they're covered by the statute only if they're brought to the United States. So in the St. Louis example, those individuals were not brought to the United States, and therefore they'd be outside the scope of the statute, I think, even on respondents' reading.
I think Justice Jackson's question got at the fact that your interpretation privileges someone who illegally enters over someone who
If Kavanaugh's
comes close to the border, and why would Congress privilege someone who illegally enters the United States? Can you answer that directly?
I think it's a bit unfair to say that we're privileging people who illegally enter, because people who legally enter are being treated better than people who illegally enter.
I got that distinction. The distinction is between the illegal entrant and the person who lawfully gets very close and wants to follow the rules. That person is disadvantaged as compared on asylum as compared to the person who illegally enters. And the question, as I understood it, is why would Congress do that? So what's the answer?
Two answers to that. The first is we would deny that the person is being privileged, because metering is not saying to the person, the polite asylum seeker, in Justice Jackson's words, you can never enter the United States and your only option is to enter illegally. It's saying our port is at capacity today, try again some other day, and that time when that person comes in, that person could come in legally. The second answer is that Congress could reasonably determine
just stay in
that
Tijuana.
the United States has greater responsibilities to aliens in the United States than to aliens in Mexico. That's how sovereignty is divided among nations in the world, and whether you got here legally or illegally, Congress could say we have greater responsibilities once you're within our borders.
More generally, or separately, I guess,
So
what
you
is
just
the problem? What was the problem that was trying to be solved here when this policy was put in place?
The policy was put in place in 2016 when ports, which might have a capacity of something like 50 or 100 people, holding capacity of 50 to 100 people, were facing lines of aliens far larger than that. And those individuals were demanding entry at that particular time, and ports were overwhelmed. Sometimes they didn't have enough food to feed the people arriving in the United States. Sometimes they didn't have beds in which they could sleep. They didn't have places where they could
But
hold
encouraging
them.
them
So
to
it was necessary
climb
for
a
the ports
fence?
to say, sorry, we're at capacity, try again some other time. And I think respondents' position is that
pulls
that is
resources
categorically
away
illegal in
from
any
moving people
circumstances,
through
because it
faster.
always violates the asylum statute and the inspection statute to say we're full right now.
That's not quite what they're saying. It's certainly not what the circuit court said. What the circuit court said was, we have a law that permits the United States to have people reside in Mexico or stay in Mexico while the application is being considered. So there is already that remedy for the government, correct?
There is a contiguous territory return provision, but
Exactly. And what the circuit said is, it's okay for you to say, stay somewhere else while we process this. What you can't do is do what the statute doesn't permit you to do, which is not to inspect me at all. The circuit said you can make a list of people and have a rational basis to tell them to come back in a particular time. But instead what you were doing was saying, you alien, we're not going to even consider your application. We're not going to take your number. We're not going to do anything. We're just going to turn you back. We're going to be the ship on the MS Lewis and ship you back to be killed wherever you end up. And that's what the statute doesn't permit. Now,
By the way,
you
Can I
mentioned,
answer
Sean?
that?
yes,
I love that we can.
That's an
I think
argument
we
that
have,
sale
even,
was wrongly
even when
decided.
we disagree, I
That's
think we have a
exactly
good
what the
group
United
here that
States
we
was
can,
doing
like,
in sale, shipping people back to Haiti.
no, because the sale made very clear that the UN obligation is if you're a refugee who's arriving at the port of entry, if you're knocking on the door and I'm staring you in the face, you have an obligation to at least listen to my application. And you can tell me to wait, you can put me in a safer place to wait, you can do a bunch of different things. What you can't do is just turn me back from the border.
And the second answer is we're not shipping people back to Haiti or whichever country the person might be
No,
coming
you're just
from.
telling them walk back.
No, we're
So
not
they
telling
can,
them anything.
the people on the St. Louis could have swam back. They happened to be on a boat. But that's what we did. They were off the coast of Florida, and we didn't let them dock. We didn't let them dock and take and interview them at all. We didn't consider whether they were being persecuted. And the majority of those people were shipped back or had to go back from where they came and were killed. That's what we're doing here, isn't it?
Like the court in Sale, I do not deny the moral weight of claims made by refugees, but that is not the question before the court. The question
So
before
tell
the,
me
Could I, would you complete your answer?
the question before the court is what obligations did Congress impose in the asylum and inspection statutes, and those refer only to aliens who
was that,
arrive
Sean?
in the United States.
May I ask you a question about the statute and about that answer? You know, I totally get that if you just look at the language who arrives in the United States, it sort of suggests, well, you have to be in the United States. So totally get that. It does seem to me that this statute, you don't have to be a superfluity hawk to think that this statute has a massive superfluity argument, problem. Because the way you're understanding that second phrase, the statute ends up saying essentially any alien who was in the United States or who was in the United States. So what led to that kind of superfluity in this statute, and how are we to understand it? It really, if you just sort of, it can't mean that, so the in the United States must mean something else.
I agree that the arrives category is a subset of the present category, but there are a few different reasons why Congress might have mentioned that subset, the same way it mentions subsets in other statutes that refer, for example, to money or property. One reason is that the arrives category is subject to special rules that other applicants for admission are not subject to. For example, they're automatically subject to expedited removal if they are inadmissible. So when the statute 1225 is talking about the arrives category repeatedly in later provisions, it makes sense to mention them separately in the definitional provision. The second reason is that immigration law has historically drawn a distinction between deportation proceedings for people in the interior of the United States and exclusion proceedings for people who've just arrived in the country. This provision, in this provision, Congress might simply have been trying to make clear that both of those are covered. The third reason is that under the entry fiction, this court had previously interpreted terms that are close synonyms for present in the United States, like found in or within the United States, exclude recent arrivals, and Congress might have wanted to make clear that it's covering recent arrivals as well. So for all those reasons, the arrives category serves important clarifying function.
It also serves a sort of confusing function. When Congress did this, it must have realized, or you would think it would have realized, that it was just going to confuse matters to essentially say the same thing twice about an alien who was in the United States. I don't think on the entry, what is it called, the entry fiction? I don't think you would have needed this second provision to do that, because you have physically present. That should have tipped people off that we're not talking about the entry fiction. And we also have the language about irrespective of the alien's status, which also should have tipped people off that we weren't talking about the entry fiction. So if I took that to be your primary argument in the brief, and I don't think it really sort of does it.
Well, if you're positing that there are already two parts of the asylum statute that are meant to address the entry fiction, then it isn't much of a stretch to say that there's a third piece as well. Secondly, the two pieces you've mentioned are not included in
It's like belt and suspenders and, whatever, a new pair of pants.
And the second point is those two pieces are not in Section 1225. They're only in Section 1158. So if Congress had included the phrase arrives in 1225 but omitted it from 1158, then people might draw a negative inference from the inclusion in one provision and the exclusion in the other.
Can I just ask?
Can I ask you, does the administration, the metering policy has been rescinded? Does the administration intend to reinstate the metering policy if it's successful in this case?
The administration would like to be able to reinstate metering if and when border conditions justify. I cannot predict in advance what border conditions will look like or what specific policy responses.
So, how is this a case or controversy?
So, Mr. Suri, why then aren't we just issuing an advisory opinion in this case?
Thank you.
I mean, your back and forth with Justice Sotomayor
I'm not
raised
moved. Harambe.
another line of questions that I had along the same lines as what Justice Barrett just indicated. At the time in which the district court in this case issued its opinion, the metering policy had been rescinded.
Read this at all because it's my quickly written chicken scratch, not for anyone else to see.
The government has no concrete plans to reinstate it. So I don't understand what we are
Keeping a running
doing
tag of some of my
other
favorites.
than advising the government in sort of the abstract as to whether or not this kind of thing is
Up
lawful.
there with,
We don't have an actual policy. We don't know who's right as between you and Justice Sotomayor about what metering actually contains, because the government doesn't have a policy in effect and hasn't shown us that it wants to have a particular policy. None is on the table. So how do we even have
Once that camel's
jurisdiction,
nose is under the
really,
tent.
to be addressing this?
The question of mootness turns on whether the court can grant any effectual relief whatsoever to the prevailing party. You can grant us effectual relief, and the case isn't moot, because there are three types of prospective orders that the district court issued that are still in place against us. The most important of which is a class-wide declaration saying we can never engage in metering at the southern border. If you agree with us, you would lift that declaration, and we'd be able to resume metering. Therefore, the
But
case
you don't,
is
but
not
you don't have a, you don't have a plan to resume it. I mean, are you suggesting that? I'm a little worried about the judiciability in the following sense. At the time the case was initially brought, there was a policy in place, the government was engaging in metering, and obviously we had a live controversy about it. But before the district court issued its opinion, that policy was rescinded. There was no more metering, and yet I think in the record it demonstrates that the parties just sort of said to the district court, well, it would be helpful if you would go ahead and enter your ruling. That's ordinarily not the case, that you don't just have the district court opining on policies that are no longer in effect. So I appreciate that the district court did, and so you would like to get rid of the order, but why wouldn't the right remedy be to just vacate the order rather than having us speak to the merits of it in this way?
If you'd like to look at the issue through the lens of voluntary cessation, you get to the same result. Yes, we voluntarily ceased metering at one point.
There are no findings about voluntary. The district court did not make findings about voluntary cessation, so I don't know how we could go there.
But the test under voluntary cessation is it absolutely clear that the conduct can't reasonably be expected to recur? And that can't possibly be satisfied here because we're telling you we want to do this policy again if border conditions justify it.
Thank you, counsel. Justice Thomas? Justice Alito?
During the period when metering was suspended, what would happen in the hypothetical situation or not so hypothetical situation you were talking about where a port was capable of handling, let's say, 50 aliens and instead 300 wanted to enter? What was done?
What was done during the previous administration differed from what was done during the Obama administration. During the previous administration, the aliens were generally paroled into the United States. And the current administration has serious concerns about that approach as a policy matter because that means that individuals who may not necessarily be entitled to asylum are allowed to enter the United States without showing that they have a valid claim, and it may be years before the person can be found and deported if that is appropriate.
Do you happen to know how many people were paroled?
I don't have an exact number on that, but it would not surprise me if it was in the millions.
Thank you.
Justice Sotomayor?
Counsel, the Office of the Inspector General issued a report that said that some of the metering that was not done because of lack of space. It reported on the fact that there were empty beds in at least 2 ports, okay? So Justice Alito assumes the moment in which there were not enough space, but there is a claim that at least one president was using this as a subterfuge for ignoring any inspection whatsoever.
Somebody.
Do you have a response to that?
Yes, I have 2. The first is that we dispute those facts, and this is at the summary judgment stage, so you can't resolve those disputes in respondents.
But we do have an Office of the Inspector General report that says that, correct?
True. The second answer is that respondents brought 2 different types of challenges to metering in the lower courts. First, a facial challenge saying metering is never okay, even if done for a legitimate reason. That's the only one before you today. And they also brought an arbitrary and capricious challenge saying even if metering is acceptable when the port is actually overcrowded, you can't use it as a subterfuge. That's not before you today.
All right. The language at issue here was passed in 1996. In 1998, the government modified its regulations to define an, quote, arriving alien as an applicant for admission coming or attempting to come into the United States at a port of entry, which is consistent with the policy that had been followed since 1980, I think it is, when the Refugee Act was passed, correct?
Not correct. The courts said in Cardozo-Fonseca, when it was talking about the 1980 Refugee Act, that the asylum statute applies only to aliens in the United States.
But the regulations have always been treating aliens who knock on the door at the port of a legitimate port of entry, have up until the metering policy, were at least giving them the opportunity to claim asylum, correct?
I'm sorry, that's not correct either. The regulation refers to an applicant for admission, and an applicant for admission.
All right, we're back in the same circle.
Yes.
All right.
Justice Kagan?
I'm going to take you back to the statute, Mr. Surrey, and the superfluity problem. You said to me the second phrase should be viewed as a subset of the first, and I want to understand what you mean by that. What does the first include that the second does not?
It includes individuals who may have arrived in the United States a long time ago, but the process of arrival has been completed. The person would be present in the United States, but the person doesn't arrive in the United States.
Is that really what you're saying? Is that your best?
That's the best you can do?
That's actually a better argument than the ones you've given so far. That the first phrase is people who have been here for some time, and the second phrase is meant to refer to people who sort of may arrive right now after this statute has gone into effect.
If you're intent on giving these provisions non-superfluous meanings, then we think that's the
Well,
right
that's a
way
good
to
thing
go.
to be intent on. I mean, because this
You
is really
insist
not
on-
like a kind of, oh, like Congress didn't see that it was doing the same thing in two different parts of the statute. I mean, these phrases are like right next to each other, and they must have meant, if you're right about what arrives in mean, I'm looking for a theory as to how that doesn't repeat what the first phrase does.
It's a subset, but that's different from saying that it has a completely different meaning and
Okay.
includes people who don't
No,
fit in the
I
first
got
category.
that, but you're essentially saying that the second phrase is a subset that's meant to respond to the fact that they've just put in a provision for expedited removal, which focuses on the same group of arriving people,
Correct.
right? And that the first provision does not really focus on this expedited removal group of arriving people, but instead applies as well, although it also applies to them, and honestly, Congress didn't really need it, but applies as well to people who have been, sitting in
given a lemon.
Kansas for the last 5 years.
Yeah, it could refer, for example, to someone who comes here on a visa. The visa expires, but conditions in his home country have changed while he's been in the United States, and so now he wants to apply for asylum. He isn't in the arrives category, but he is in the present category.
Pretty limited
Thank you.
Justice Gorsuch?
example.
Justice Kavanaugh?
Is it lawful to impose the metering policy for the government to do that, even if a port is not overwhelmed?
We believe that it is lawful, but we're not asking the court to go that far today. The only issue before the court today is this facial challenge to metering, that it always violates the inspection and asylum statutes. There are separate claims that it would be arbitrary and capricious to engage in metering as a subterfuge, but that's not the issue
Okay,
here.
it wouldn't be a statutory issue, it would be an arbitrary and capricious issue then.
That's the claim that's been raised by the other side.
Okay. And you make an argument, this is a relatively minor point, but it's in your brief, and I didn't agree with it, so I'm going to bring it up, which is page 25. You say that because it's in a parenthetical, it's different than if it had been separated by commas or dashes. Do you really mean that?
Yes, I
I mean,
do
I know we have a
recognize-
case in a particular context that once said that, but I don't know that that's a general rule that parentheses are different than dashes in interpreting statutes.
I recognize that
Or
you
commas.
dissented in the case we're relying on.
Yes.
But
But do you think that's a general proposition, that parentheses are different than dashes or commas in interpreting statutes?
not that they're different in that sense, but that they convey an aside, and that material in parentheses, or for that matter, even in dashes, don't override unambiguous language outside
Nerds.
the parentheses or dashes.
Or commas?
I think commas
I
grammatically
just don't
are
want
a
this, I mean, I was surprised to see this, and, the Constitution has things in parentheses, and I'm just trying to make sure that this doesn't expand.
The court does not need to rely on that argument.
Thank you.
to rule for us.
Justice Barrett?
Mr. Suri, when I asked if the administration intended to reinstate the metering policy, I didn't intend to suggest that it was formally moot. And it was my understanding, I just wanted to clarify it, that the injunction in this case still has continuing effect on members of the class because it still matters.
That's right. There's a declaration that has continuing effect as to the whole class. There's also an individual injunction that has continuing effect as to one particular plaintiff, Beatrice Doe, whom the district court ordered us to allow into the United States, and that's an additional basis for avoiding any mootness concerns.
And that's why the Ninth Circuit said it wasn't moot.
That's right, and that's presumably why the other side hasn't raised a mootness argument, and why, even though we discussed mootness in our search stage papers, the court still granted review.
Thank you.
Justice Jackson?
So under Atchison Hotels, why wouldn't we still not reach at least the injunction, because Mrs. Doe apparently has represented that she does not intend to return to the United States, and the injunction is specifically requiring the United States to facilitate her entry.
In the Atchison case, the plaintiff dismissed that plaintiff's claim and told the court that the plaintiff was abandoning her claim entirely and acquiesced in vacatur. There's nothing like that.
She would have to do more, you're saying, than to say, I'm not coming back to the United States.
I think it's far too late to do any of that now because we also have the class-wide declaration that independently keeps this case live.
Right, let me talk about the class-wide declaration. You're asking us to reach the merits of whether or not metering is lawful and reverse the district court's judgment on that basis. Why isn't vacatur a permissible remedy here? I mean, I understand you'd like us to say today metering can be done, give you the okay to do it. But another way to address this, I would think, given that the district court declared a policy unlawful even though the policy was no longer in place, and the government today is saying it has no concrete plans to reinstate it, and the district court issued this order without making any findings about whether or not a live case or controversy existed, I think one could argue that the district court at least abused its discretion by nevertheless entering this broad declaration. So it would solve your problem, I think, if the court on those grounds just vacated it.
No,
why need we get into giving you an answer on the merits of the question of whether or not metering is lawful?
The Ninth Circuit reached the issue of mootness and issued a ruling on that issue. I think it's the first footnote in its opinion. So unless you determine that that mootness holding was wrong, there's no basis for disturbing the Ninth Circuit's decision. And on mootness, we think the Ninth Circuit got it right. This case isn't moot because we'd like to reinstate metering and we're being prevented from doing so.
But you don't have a concrete plan, I just want to make clear.
Concrete plans are necessary for standing.
For standing.
Not for mootness.
All right. Let me just ask you one question about your response to Justice Kagan. You were talking about the various reasons why Congress had arriving in this statute, and that one of them you said was the fact that there was previously a distinction between deportation and exclusion, and that Congress was trying to ensure that that was also covered, or that the principles related to deportation and exclusion were covered by this new regime. My understanding is that exclusion applied to people who were, quote, at a land border, at a port. But your reconceptualization of what arriving in is doing does not allow for at a land border or at a port. And so can you help me to understand how Congress could both be attempting to ensure that those principles were included, but we still agree with your reading of the statute?
The phrase at a land border in this context refers to people on the U.S. side of the border rather than the Mexican side of the border, and we know that in two ways. The first is the court's entry fiction cases, like Kaplan against Todd and Leng Mei Ma, repeatedly refer to aliens on the U.S. side of the border who've just arrived.
In the entry fiction context, but we don't have a case or a scenario in which Congress makes clear that it's responding to the entry fiction when it uses the words arriving at, right?
And the second answer is that in Cardozo-Fonseca, when the statute said at a land border, the court understood that to refer to aliens in the United States.
Thank you.
Thank you, counsel.
All right.
Ms. Corcoran?
Mr. Chief Justice, and may it please the court. In the 1980 Refugee Act, Congress established a statutory process for non-citizens fleeing persecution to seek protection in the United States. Congress designed the scheme to track the United States treaty obligation not to refoul refugees to territories where their life or freedom would be threatened. Because refoulement includes, to quote Sale, defensive acts of resistance or exclusion at the border, the Act requires immigration officers to process claims not only for non-citizens already present in the country, but also for those arriving at ports and elsewhere along the border. For decades, port officers followed the statutory procedures designated by Congress for inspecting and processing arriving asylum seekers. It was not until 2016 that the government asserted for the first time that it can wholly avoid these mandatory duties simply by blocking asylum seekers just as they are about to step over the port threshold. Petitioner's theory of the statutory text isolates the word in at the expense of making the rest of the statute nonsensical. By petitioner's account, the phrase arrives in the United States has no meaning not already covered by present in the United States. Arrives means already arrived, and amendments that Congress intended to encourage non-citizens to lawfully seek admission, in fact, did the opposite, permitting border officers to effectively eliminate access to asylum at ports. Petitioner's position is also at odds with the original public meaning of the provisions, reflected in the government's longstanding inspection practices at the time of IRA's enactment, and in the government's own regulations, which have recognized for nearly 30 years that the Act's inspection and processing duties apply to non-citizens, quote, coming or attempting to come into the United States at a port of entry. As this court observed in Thoracicum, Congress carefully crafted our asylum system to ensure that the United States lives up to its ideals and its treaty obligations towards non-citizens fleeing persecution. The turn-back policy flouted both, and the Ninth Circuit was correct to deem it a withholding of the government's statutory mandates. I welcome the court's questions.
How would you distinguish this case from Sale?
Yeah, this case is distinguishable from Sale in a number of ways. One, Sale involved the withholding provision alone. It didn't involve the statutory mandates that are at issue here in 1225, the inspection and processing mandates. So here we have a 7061 claim about whether the government has withheld compliance with those mandates. Sale is also different from an extraterritoriality and a treaty perspective because it involved interdiction on the high seas, which, as Sale explained, is outside of the jurisdiction of the United States, so it raises a host of questions that aren't raised here. I'd be happy to address some of the points my friend made.
Could you address 1157?
Yes. So 1157 is the refugee program. My friend takes the position that we have collapsed the distinction between the two. Our position reflects the way that 1157 and 1158 operated from 1980 to 2016. So for 36 years, no one was concerned about the distinction being collapsed, and that's because they serve two entirely different functions. Section 1157's refugee program is entirely elective. The president chooses whether to admit refugees. It's not something that refugees in other countries can apply for. It's decided between the countries. There are a host of benefits you get if you are admitted through that program, but 1157 is not the provision that implements the Article 33 obligations. That happens through the asylum processing that's under 1225 and 1158. And that asylum processing is also how you determine whether someone is entitled to withholding.
Mr. Suri gave some responses to Justice Kagan in saying that there's a subset of people who are arriving in the U.S. who are, as opposed to longstanding people. The problem with that is those people who are arriving, he says, are present in the U.S. So I'm not sure how his answer gets you around the surplus problem.
Yes, I agree. My friend made a number of new arguments about surplusage that weren't in the briefing, and I think that is one of them. But I would note exactly what you said. Making it a subsection doesn't mean that it's not redundant. It's still entirely redundant.
Well, that's true, Ms. Corcoran, that it's a subset, and so there's still redundancy. But I suppose if Congress in IIRA had just created this big deal about expedited removal and said that expedited removal was what arriving people got, it might be that they just wanted to emphasize that just because you were that you were subject to the expedited removal procedures did not mean that you still couldn't apply for asylum. So the fear, if you might say, is that if they had just had that one physically present in, provision and struck out what had previously been in the statute, the arrive at the port provision, somebody might have thought, like, all these people that are now being subject to expedited removal do not have the right to apply for asylum. And this provision is supposed to make clear that they do.
There's no reason for the inspection mandate to need to make that clear because 1225B, the asylum processing section, it's in B12A, has a whole process in place for how you assess asylum claims by arriving aliens. So that credible fear interview provision says if an immigration officer determines that an alien who is arriving in the United States has expressed a fear of future persecution, then the immigration officer shall refer them for a credible fear interview. And then there are a host of provisions that explain how that credible fear assessment plays into expedited removal. So there would be no way that someone could read the entirety of 1225 and be concerned about how it applied to arriving asylum seekers.
Can I ask you a question? I feel like there's some slippage between arriving and arrives, and as the Chief Justice pointed out, the language is arrives in. I mean, arriving sounds more in the process of. Arrives in sounds more like you've reached your destination.
But arrived.
How do you know under your theory when the person is close enough that we could say they have arrives in or arrived in the destination? I mean, what if there's a queue and they're far back? How close do you have to be to the border? Could you say that someone arrives in the United States if they're at a portion of the border that does not have a port of entry? Like, what is it? If it's not crossing the physical border, what is the magic thing or the dispositive thing that we're looking for where we say, now that person we can say arrives in the United States?
So I'm going to try and keep that in order in my head, and I'm going to start with the first point, which is actually
all right, guys, that sounded like a very me
that triggers
response.
the inspection under 12258, but is arriving in is the language that triggers the credible fear interview. So that's the provision under 1225B that mandates asylum processing within the context of expedited removal. As the government acknowledges, and I think Your Honor just said, is arriving in does suggest a process. And in fact, that's exactly, that determination is what's happening under the turn-back practices. So they have immigration officers standing at the border, asking arriving non-citizens, what's the basis for your admission? They get right up to the borderline. And if they say, I'm here seeking asylum, then the border officer turns them away when, in fact, 1225B says that if the immigration officer determines that the person is seeking asylum, he shall refer that person to a credible fear interview. So that argument stands separate from the inspection mandate. Now, what used to happen is that you'd have inspection, and that's how you'd find out someone had a fear, and then that would trigger the credible fear interview. But both of those provisions are at play here.
Okay, can you answer the question about what is the dispositive thing that has to happen to say that someone arrives in?
Yes, so a person arrives in the United States at a port of entry when they are at the threshold of the port's entrance about to step over. So they are arriving there. I think that's consistent with ordinary meaning. I arrive at my house or I arrive in my yard when I'm going through the gate. Now that process of arriving is interrupted by the border officer physically blocking them from completing the arrival such that the person never arrived, but the process of arriving is beginning at that moment.
And is that just for the person? I mean, if there's a line, you know, and you're far back and you hear, oh, no, we can't cross the border today, have they arrived in and been turned away, or is it only the person initially told? And how could it be something different if you arrive at a port of entry versus if you cross the border or you arrive on the other side of the border, the Mexican side of the border, but say cross into Texas or try to cross into Texas where there's not a port of entry?
Yeah, so to start with the hypothetical where you have a line growing, I think that our position is not that arrives in the United States is doing no work at all. The question is what arrives in the United States at a port of entry means. And I think that means you have to be at the threshold. If I'm in a line waiting to get into my house for some reason, into my yard, and I'm half a block back, I haven't actually started the process of arriving in because I'm in a line waiting to get there. So I think, you know, if the word was being passed down a line that's going over the bridge and people are turning away without actually getting to the threshold, they wouldn't fall under the statutory inspection mandate or processing mandate. The second question, I think, has to do with how arrival looks between ports. As a practical matter, the borderline isn't generally delineated in a way between ports that would allow for this kind of discernment about have you reached the threshold of the port.
Doesn't the statute say whether or not at a port of entry?
Yes. So I was going to get to that part next. So we take out at the port of entry when we're talking between ports, and the question is, what does it mean to arrive in the United States? I think you would have to be at a place where you could, in fact, cross. So if you got up to, let's assume it's a place on the border where there is an actual line, identifiable line, I would say the same analysis applies, right? Have you made it to the threshold and you're about to step over?
So anybody at the water's edge of the Rio Grande on the Mexican side has arrived in?
No, the border is halfway through the water.
All right, so they've got one step short of halfway through. They've arrived, but somebody who's on the water's edge has not arrived.
Yeah, I think that's right. So you're looking at being at the threshold of when you're going to cross
And so
the border.
somebody who's at the fence has arrived in, but somebody a step away from the fence has not arrived in?
Well, so the fence, if we're talking about the border wall,
Yeah.
that is, the border wall is entirely on the interior, so in fact, anyone who gets to the border wall
They're already
is
in.
also physically present in the
So
United
anybody
States.
who's arrived at the fence is in?
Yes, but that's just a matter of geography, that
Yeah.
they're already present. To take the hypothetical, though, what if there was a
Fence
border
along the
wall
line, yeah.
exactly on the
Yeah.
border line? There, the analogy that I think of is a stadium. So I'm arriving at a stadium when I'm at the entrance going through the turnstile. I probably wouldn't describe myself as arriving in the stadium if I'm still on the perimeter making my way to a place where I can enter. So I don't think
So if they're
someone
at
who's
the
out of...
top of the wall, they're in, but if they're at the bottom of the wall, they're out.
Oh, so now they've climbed.
Yeah. No, I'm just trying to understand what it means.
Yeah, so I suppose...
We're going to get these,
Yeah.
we're going to get, as soon as we decide what it means, we're going to get cases.
Well, so as a practical matter, that's not going to be a concern because the wall is in fact within
I
the
understand.
perimeter. A hypothetical wall that was on the line and a person had kind of gotten to the top and was about to fall over, I guess, would
Yeah,
potentially
the
be
end.
arriving. It would be
How come somebody who's in the line isn't in? I mean, if the whole point is to make sure that people who are attempting to get into the country have the opportunity to file asylum claims, and they've made it all the way, why does it matter he's second in line?
I think that's just a function of arriving in or
So
is
the whole
arriving.
debate boils down to the one person who's at the port, the one person who's at the front of the line.
Yeah, and I think that's because, I think it's important
So
to
the rest of
remember-
the case, you agree with the government on?
No,
And everybody else in the line, everybody else who's being metered doesn't have an asylum claim, just the person who's,
They have an asylum claim, they have to get up to the border to present it. Now, I think maybe the question is if the government was stopping people from getting physically to the line, because if you're waiting in line and you just decide to abandon waiting and you don't actually make it to the
no,
threshold.
no. These people want to make these claims. They're there.
Right.
And
so
they're
if
being
they-
metered and they're told, no, not today. And you're saying the person who's made it up to the inspection officer gets to make that claim, and everybody else who's been waiting there maybe for hours or days doesn't.
Well, they just then, once they get up there, can make the claim.
But they
That's
have
when
to get
go.
up there, yeah.
Yeah, but there's no reason to think they wouldn't be able to do that. And I think it's important to remember that from 1917 to
Didn't quite follow that.
2016, 99 years, there was not a single example of a turnback. So what was happening is people would come through the port. At that point, when they were in the port, they would be inspected and processing would happen. So it's an unusual scenario we have here where we have the officer standing there and turning people back.
And now we have
By the
these
way, for those of you who've
expedited
never waited in this line,
removal processes.
even if you're an
at the
American
border.
citizen, it's a
So many
3-hour
of them are
line.
not getting in at all, but they're coming to the line and they're at least being questioned and permitted to make the claim.
Under the expedited, if they were being applied the way they're
I
supposed to.
think your point that you're making is the statute's very clear that anyone in the U.S., now the other side says a foot. I don't know why the foot is magical. I could put my hand through or my nose through. I don't know. Why does a foot count as opposed to a piece of your body count? So if you're up on the top of this wall that's not on the U.S. side. But my point is, in asking or clarifying this question, is arriving at the border means you're knocking on the door.
Agree, Jordan.
correct?
It was
That is what it
like
has
a-
meant for 99 years before. this
Mr.
was
Surya suggested that's not what it meant, that that's not what the federal regulations said, that that's not what practice was. Was he simply wrong about that? In
Yes.
reading the papers, I understood that up until 2016, anyone who knocked on the door had the opportunity to make the claim, and they weren't guaranteed success, but they could make the claim.
That's right. So the government purports to cite a few earlier cases, which it says support its position. That's Lang Mei Ma, Hong Kai Chu, Meze, the Ellis Island case. All of the cases that the government is citing, its sites are playing fast and loose with entry. So each one of those non-citizens was present in the United States, arrives in the United States, at which point they were subject to exclusion proceedings. That's the statutory process that you got if you arrived and then you weren't actually admitted or physically present in the country. That is all that, we're just looking for the statutory process to be applied to our class members, or we were when this policy was in effect.
I just want to make sure I understand exactly. There's a line of 50 people trying to get in. The first one knocks on the door, so maybe he or she is processed. I don't know how many people are there processing, but if there's one person there, maybe person 3 to 50, they don't have a claim, right?
Yes, so
No, wait, yes or no? Do they have a claim or not?
they are going to have it's going to depend on whether it's a reasonable delay.
Well, what do you think a reasonable delay is?
Well, so that's under 7061. I think Justice Sotomayor made the point earlier that the Ninth Circuit made a determination that this was complete withholding because there was no ability to wait. There was no ability to put your name on any sort of meaningful list that would ensure that you were going to.
So it's not knocking on the door, it's getting your name on a list.
So it's a turnstile if you're at a land port and there's a plaque halfway across the bridge, so not a physical door. But yes, so when you go through the line, if it's working the way it should, you should make your way up to the borderline, at which point you come across and you are processed.
Maybe I just don't understand. I mean, it depends kind of on how long the line is, right?
Yes,
always long.
There were non-examples prior to the turnback policy, and even during the turnback policy, of there being kind of lines of people waiting to be processed who are outside of the United States because under the prior practice, you came through the turnstile and then you were inspected and processed. Now, there could have been long waits within the port. That certainly happened, and that would have been subject to kind of a reasonable delay analysis. But this idea of kind of lines and people piling up on the Mexican side of the border didn't happen until the turnback policy was put in place, and you got this bottleneck of people waiting on that side.
No, I understand that, but I'm still struggling with the Chief's question, and we do have situations where there are lines, and I had thought you'd said to me and Justice Sotomayor or others that the first person at the turnstile with the inspection officer has arrived, but people further back in the line haven't. And now I thought I heard a different answer to the Chief Justice, and I'm just wondering, I really do, whatever you think it is, I want to know what it is.
I think I was skipping ahead when I answered the Chief's question to kind of the nature of the 7061 claim and the difference between withholding.
I'm just curious what
Yes.
arrives in means.
Arrives in means you reach their threshold. I didn't mean to create confusion about that when I was answering.
Okay, so it's the person at the
Yes.
turnstile, it's the person halfway through the Rio Grande, not somebody 2 people back, not one person back, not one person who can't reach across the halfway point of the Rio Grande, none of that.
Yeah, you have to reach the threshold in order to be subject to the 1225 mandates for inspection.
So how does that
policy.
fit, Ms. Corcoran, with 1225B1A(i), which says if an immigration officer determines that an
we're splitting
alien
hairs
who's
that don't need to be
arriving in
split.
the United States is inadmissible, the officer shall order the alien removed from the United States. Now, to me, that suggests not you remove somebody from the United States when they already have crossed the threshold,
Yes.
not when they are knocking at the door. So that suggests to me that arriving in suggests that they've already crossed.
So it's a process of arrival. So the person is arriving in when they're about to step over the threshold. And again, I would go to the plain meaning, and I think about kind of being at a house or a yard. If my husband called and said, "Are you arriving at the house?" as I'm walking through the door, and I said no, that would be a strange answer to give him. The ordinary meaning is, yes, I'm
Well, but if
crossing
it's
through.
arriving in, the officer shall order the alien removed from the United States. That seems to suggest that your view of plain meaning, whether it is plain or not, is not the statutory meaning, because if you're removing somebody from the United States, that person has clearly made it over to the United States. You don't remove somebody from the United States when they're just knocking at the door.
Well, so I think that provision makes sense if you remember that removal is a legal term. It refers to removal proceedings. So what that provision is assuming is the completion of arriving. And because in 1996, when Congress was drafting the language, it had no reason to think that 20 years later, the government was going to change its position and start blocking people while they were in the process of arrival. So you see in the regulations, and I think also in SAIL, kind of the understanding that the process of arrival starts when the person is at the threshold, and it continues as they step over the threshold and are being inspected. So I don't think there's an inconsistency there.
And so to clarify, when the person is arriving at the
Picture for you
threshold,
guys that gives some sort of a.
process of inspection, you say, kicks in based on their arrival. And that process could take place on U.S. soil, presumably without metering.
It's hard to
Inspectors are on the U.S. side, and so they're asking
First time
and they're
I saw it-
investigating, and the person is in the U.S. at that point. But the obligation to do that kind of inspection, I think you're saying, kicks in based on the person's arrival.
Yes, that's exactly right, and it
I
makes
actually
sense when you
didn't
remember
get
that is how
in
it had worked
line
from
for a while the first
1917
time
to
because I assumed
1996 when Congress was
there
amending
must
the
be a
provisions.
different line.
Can you
I hate
speak
to
a
say to admit this, but
It'll be interesting to
there must be a different
read the
line for
actual
American
transcript
citizens.
of
There's
the
no
oral
way
argument
I have to
because
wait in a line this long to get back
I
into my
believe
country.
that both you and Justice Sotomayor and Justice Jackson on several occasions have used the phrase arriving at. I think you said you arrived at your house, but that's not the term that is in
once you're in
the
it, you
statute.
really can't
Do
get
you
out
think
of
there
it.
is no difference between arriving at a location and arriving in the location?
Yes, thank you for the opportunity to clarify. So we have in the United States at a port of entry. I can explain the amendment history on how we ended up with the prepositional phrases in that order, but I think that my first order answer is in is just how you describe. I'm arriving in Baltimore when I'm on the train as it's coming in. I am at Penn Station when I'm in New York. So that's the difference in prepositional phrases, which even if it doesn't completely answer the question, does give you some pause to say, well, maybe in isn't doing the work that the government is suggesting here because it has to do with kind of the natural way that we talk. But the way we ended up with that order of the prepositional phrases is that
Well, I'm not quite sure I understand that. So there's been talk about knocking at the door. Do you think someone who comes to the front door of a house and knocks at the door has arrived in the house? The person may have arrived at the house.
No, but that's past tense. Are they arriving in the house?
Does a person arrive in the house when the person is not in the house and is knocking at the door, asking to be admitted to the house?
Yes, I think here the door is open. The officer is standing on the other side of the threshold. The person gets there and is ready to take the step over, right? The officers and the asylum seekers here were toe-to-toe. This was happening right at the line, and they're about to step over. They are arriving present tense. Once they're inside, they've arrived past tense, but we know that Congress used the present tense here.
Well, it does make, I gather you think it makes a difference. Whether there's a door or a turnstile, you have to be there. If you're at the end of a long line, you're not there. You haven't arrived at the turnstile.
Yes.
Okay, so then does it matter how many people are processing the arrivals? I mean, how quickly the line's going to move? I mean, it strikes me as a very significant factual question. In other words, it's not, if you're at the end of the line, you're not covered by the requirement to process. Is that right?
Yes. So once you get to you have to arrive, and that's just the nature of the language that Congress used. However, if the government was complying with the inspection and processing mandate, people would be going right through the turnstile. There is no stopping or processing that happens at the turnstile under the prior practice. A person goes through, and at that point, they're
So you don't even have to knock?
No, there was no knocking. You went through. There was no immigration officer who was stopping you. You're going straight through the open door. You are now in the inspection area. You're in the port. And at that point, there would be perhaps a delay of processing for the reason you say. That delay would be subject to 7061, unreasonable delay.
And then another
Here
couple
we have
hours.
complete withholding. But I think maybe where we're getting stuck is kind of the idea that processing is happening at the border. That only happens under the turn-back policy. That's the only situation in which you're going to have immigration officers interacting with asylum seekers on the other side of the border.
So historically, if you were at the end of the line, you still went through.
There was no line. People just...
Right, there was no
constant-
line.
Yes.
This
exactly.
only became an issue, is what you're saying. And so the arrives in wouldn't have had the significance in 1996, is what based on a historical practice, and now we're trying to figure out what it means when there's a new practice not envisioned by Congress.
Yes, that's right. And if I could go back to something you said earlier, which is the logic or the logical problem the government has with treating this kind of the change in language as if it suddenly substantially narrowed access to asylum at the ports. Not only is that illogical, but it defies the express purpose that the text was seeking to achieve.
Maybe that you're not wrong, but
we
let me
know that the
give me a sec.
reason that Congress amended 1225A1 was to expand the category of applicants to include people who were already present in the United States and people who entered between ports because it needed to put them on equal footing. So to read that language as then
just watched a
re-disadvantaging
frickin' video
people
or
who attempt
done
to enter lawfully makes no sense at all.
Pictures
Can
or
I ask
something.
you, this is a new practice. Justice Kavanaugh just said a new practice not envisioned by Congress. The Chief Justice says we have a significant factual question here about how this actually works. Why wouldn't we wait until we had an actual policy with real facts in the record regarding what's going on? I mean, even if this is not technically non-justiciable, even
Actually,
if
BC,
there
the answer to your question is both.
jurisdiction in the literal sense, we do have some control over whether or not we reach and discuss issues. And it just seems to me that we have a lot of hypotheticals regarding how this policy may have worked in the past, how it's possibly going to work in the future, but we don't have a policy in effect right now that we can actually rule upon. So how should we take that into account as we think about this?
Yes, thank you, Your Honor. So as we explained in pages 15, I think to 21 of our brief in opposition, this case has virtually no ongoing significance, certainly not for the plaintiffs. Now, the government has sought this court's review because it wants to preserve its degrees of freedom in the future. Right now, the border is closed under other authorities, but maybe if that's not true in the future, conditions change.
The definition
that is not a
is
reason for this court to grant plenary review. And government suggested—
I mean, if the government were to just bring its own action, I think Mr. Suri has conceded that they wouldn't have standing because they don't have an actual plan in place that they're trying to implement.
Yeah.
What they're doing is saying we have this, essentially extant district court order out there, and at some point in the future, we might want to have a policy like this. So Supreme Court, tell us now whether or not that's going to be unlawful.
Yes, that's what they're seeking. That doesn't, in order, as the court said in Camreta v. Green, both parties have to have a live interest in the case in order for the court to proceed. And that explanation doesn't go to how plaintiffs continue to have an interest in a declaratory judgment against a policy that was rescinded 5 years ago. And so I think it's odd to raise the voluntary cessation exception here, where it's the defendants who want to continue
Absolutely.
to do the policy.
Usually voluntary secession is the defendant wanting to avoid the court's orders.
And
they remove the policy so that the court doesn't order.
Right.
Here we have them pointing to the voluntary secession as a reason for the court to weigh in on this policy.
Right, and it's the government that's saying, the government has control over the extent to which it's likely.
Counsel, do you think the Ninth Circuit was wrong to say that it was not moot then? You didn't challenge that in your brief.
No, so what the Ninth Circuit said that the declaratory judgment was moot and the dissenting judge agreed. The reason that the Ninth Circuit reached its holding was because of the transit rule injunction, that smaller class, which at that point, that injunction was still in place and imposed a number of obligations on the parties. So the Ninth Circuit was not wrong about that. But on remand, the parties agreed to essentially dissolve the injunction because the burdens that it was placing on the parties no longer had any benefit to the class members. The class members had been identified.
So you're taking the position it's formally moot?
I do think it's moot for the reasons—
Why didn't you make that point in your brief?
We wrote 6 pages of all the reasons
In the bio?
we thought— yes, in the brief in opposition. It wasn't until the reply in support of cert that the government suggested Munsingware vacator. I'll say we don't object to that. We didn't address it in our brief in opposition because that would be an odd thing for a respondent to suggest. And once the court granted review, we focused on the merits. But to Justice Jackson's point about Munsingware vacator, we don't have an objection, and I think that resolves all of the government's concerns in this case.
Thank you, counsel. Justice Thomas? Justice Alito? Anything further?
On that last point, the court said the declaratory judgment, it was vacating that. And it's also vacated the preliminary injunction?
No, so the declaratory judgment is still in place, but I think is moot for the reasons that the Ninth Circuit said. The Ninth Circuit went on to reach kind of the statutory interpretation question, not with respect to the declaratory judgment, but with respect to the transit rule injunction, which would only be in place if the underlying statutory question was resolved in the plaintiff's favor. But then that injunction was dissolved, so we really have nothing that's before the court at this point.
Thank you.
Justice Kagan?
Is your position that when a person gets to the border, she has a right to apply for asylum only, or that she also has a right to enter?
So enter so a right to cross, I'll say cross.
A right to
avoid,
cross.
The entry. So I think the right to cross is tied up in the inspection and processing mandates that are on the government. So we have a 706(1) claim here. It's based on ministerial duties that attach to the government under these circumstances.
And if the United States figured out a way to do its various things that it has to do without having the person cross, would that be sufficient? Like you could have a Zoom interview or something like that.
Yeah, I suppose that 1225 assumes that all of this is happening on U.S. soil, and I think for good reason, because that's how it already worked. The government's extraterritoriality concerns might weigh against doing some sort of process, but I don't know that I have a stake in pushing back on that way of approaching things.
Okay.
Justice Gorsuch, anything further?
Just briefly. You mentioned the Court of Appeals revised opinion. It said it didn't think the case was moot because of the equitable relief still present, which I took to mean both the declaratory judgment and the injunction.
That's all I can hear now. BC?
So yes, they were both left in place. The reason that the Ninth Circuit reached the underlying statutory interpretation question was
because they were both in place. Yeah. Okay. Thank you.
Justice Kavanaugh?
On that question that you made a point on about why Congress would give better treatment to those unlawfully in the country, I guess one response to that, and just want to get your reaction, would be we should just interpret the rule in front of us or the statute in front of us by its terms and not try to figure out all the things that might be going on with people unlawfully in the country to try to make it all fit in some perfect world. Rather, we should, there are lots of issues with people who are unlawfully in the country but the only issue before us is trying to figure out what arrives in means and not worry about that. I just want to get your reaction to that.
Sorry, I'm not sure I followed the question.
You were saying that if we interpreted it the government's way,
Yes.
that Congress would have been privileging people unlawfully in the country. And my response or my question to you is, whatever's going on with people unlawfully in the country, the sole issue before us is trying to figure out what arrives in means when you're at the border, and whatever the effects of that are in terms of creating disparities, we can't sort all that out here. All we have to do is focus on the issue before us. So what's your reaction to
Yes,
that?
thank you. Sorry, it took me a little bit to get there. So I think it's less about advantaging people who are already in than it is about addressing the disparity incentives that Congress was trying to resolve in 1225. So under the government's framework, if you are an asylum seeker coming to the United States, you should not go to a port because you will be turned away. You need to cross the Rio Grande, you need to come in between ports. That is the exact opposite of what Congress was trying to accomplish there. And I know also—
But the answer to that could be better enforcement of people coming in unlawfully, and Congress might have assumed, particularly in 1996, when there was an increased effort to prevent illegal immigration.
No, they absolutely did not.
People wouldn't be flooding in unlawfully. That
No,
turned
they
out
did not
to be
assume
accurate,
that
but
in
might have been the
1996 when we
expectation in 1996.
barely
So-
enforced
but I don't think that then
border
explains what
in
Congress
1996.
was doing in 1225. It creates this applicant for admission category in order to unify the proceedings, the deportation and exclusion proceedings. What the government is suggesting just makes all of that somewhat nonsensical.
Okay, completely different question, last one. This seems very artificial, trying to figure out at the threshold, on the line, in the middle of the river, because wherever the line is, the government's presumably going to stop you on the other side of that line and prevent you from getting to wherever the line is, right?
So that you're getting across the line.
Yeah, so if we define it as the threshold, the government's going to stop you short of the threshold or try to.
I understand.
And if we say 100 yards from the threshold, they're going to stop you 125 yards from the threshold. In other words, the point, I guess the arrives in thing seems kind of artificial. The whole question, the bigger question, it seems to me, is can the government physically stop people before they get to whatever that line is, no matter how we define it? And that seems like not a statutory question, more of an arbitrary and capricious question, but maybe I'm wrong. Just want to get your reactions to that. This whole idea, if you're second in line, or for the government, wherever we define it, is going to stop you when they want to implement this policy on the other side of that line. You follow that?
I do, and so I think that maybe the factual premise that's inaccurate there, the port goes right to the borderline. So the government understands ports as being kind of that geographic space. So the threshold of the port is the borderline. So you can't really, if you move the threshold further in, then you have people who are present in the United States. If you move the threshold further out, well, now we're in Mexican territory and the government doesn't have authority to act there. So
Well, that's, okay, so that's a good answer. Does the government, how far into Mexico, maybe the SG, will the government go? Maybe they don't want to answer that, to stop people.
Yes, I think if the government starts going well into Mexico,
Well,
and
the
starting,
well into, is that 100 yards? I mean, 150 yards? That's not the threshold anymore, and will they go into, I mean, again, you might not have the answer to this question, but the whole thing seems kind of artificial to me, because the government is going, if they want to do this policy, they're going to stop you on the other side of the line.
yes, and I would say there that so if we start to have the government kind of circumventing further into Mexico, whether it's 10 feet or 100 feet, we move out of the inspection and asylum processing mandates in 1225, and now I think it's a question of just kind of ultra vires acting without authority in another country.
All right, thank you for.
Hey, Jordan. Oh, good. Okay.
Justice Jackson?
Never mind.
We don't have the answers to
I think I
Justice
just fixed it,
Kavanaugh's
double
good
saying
questions
everything you said.
because there is no policy in effect, right? We don't know.
That
what
is
the
right. I was
government
going to
is
make
doing.
that point as well, right? Right now, we have a legal question that's unanchored from any actual practice before the court.
Thank you.
Thank you, counsel. Rebuttal, Mr. Suri?
All right. Almost wrapped.
Just a few quick points, Mr. Chief Justice. First, this court should decide this case. The case is not moot because there is still effectual relief that the court could award, namely lifting the class-wide declaration and the individual injunction to which the government is still subject. There's also a strong practical reason for the court to decide this case. Administrations of both parties since 2016 have consistently said that this is an important tool in the government's toolbox for dealing with border surges when they occur. I can't predict when the next border surge occurs, but I can say that when it does occur, this is a tool that DHS would want in its toolbox. It's not something the court should leave to future uncertainty. We've been faulted here for not having a specific policy in place, but that's not really fair to us. There's a class-wide declaratory judgment saying that this practice is unlawful, and I think the government should not be faulted for conforming its current conduct to what a court has declared to be the law. Once that declaratory judgment is lifted, we'll take appropriate steps at that time. Second, the text of the statute should control the court's decision, and that text is arrives in the United States. We've heard attempts to substitute other language that might be more ambiguous or more susceptible to respondents' interpretation than the language Congress actually used.
Use the
For
definition.
example, we've heard many references to arriving in the United States, but the specific language at issue
Not
here is
arrived.
arrives, not arriving.
Not arrived.
Further, as Justice Kagan correctly pointed out, there's a separate provision of Section 1225 that says that arriving aliens can be removed from the United States in certain circumstances. And that suggests that even the arriving category is limited to aliens who've already crossed the border. Even if you think that there is some ambiguity in the term arriving, though, the correct approach is to use the clarity of arrives to resolve the ambiguity in arriving. You shouldn't use the ambiguity potentially in arriving as an excuse to ignore the clear word arrives. Similarly, we've heard attempts to replace arrives in the United States with arrives at a land border, or arrives at the threshold, or knocks on the door. None of those terms are the terms Congress actually used in the statute. Moreover, even when a previous version of the statute said arrives at a land border, this court still interpreted that to refer to aliens in the United States. We've relatedly heard a suggestion that the alien arrives at the port of entry because the port goes right up to the border. We don't think that's accurate. The entrance to the port might be something like a quarter mile from the border. So even if you think the question is whether the person arrives at the port, the person hasn't arrived at the port. More importantly, the real question is whether the person arrives in the United States. Finally, respondents' position raises serious line drawing problems. It's not clear from their position whether you have to be at the front of the line.
I have a drawing to
back
deal
of the
with this in
line,
a second.
Or the middle of the line. It's not clear whether they're distinguishing between someone who is stopped by a border
I'm gonna
officer
show you
versus someone who is stopped by the Rio Grande versus someone who is stopped by the border wall versus someone who is stopped by Mexican authorities working in concert with the United States, which is something that could happen in response to Justice Kavanaugh's question. I don't think we'd ourselves go into Mexico, but we could cooperate with Mexican authorities to stop people from reaching the border of the United States. Our position avoids all of those line drawing problems because Congress drew a clear line here. It said that if you're outside the United States, you can apply for refugee admission under Section 1157. If you're in the United States, whether you've been here for a long time or you've just arrived, you can apply for asylum. The court should respect the line that Congress drew.
Thank you, counsel. Case is submitted.
Case is submitted. Okay. Oof. Let me close that off and we will finish this up. All right. So first of all, I want to show you guys this and let me see if I can make sure that it's visible. So here's what I wanted to show you. This is based on my experience of walking across the border, which is not normally what I did. Usually I drove. Actually, let me start with that. So the idea is they're only allowing, just gonna pick a random number. Let's say they will allow 10 people to apply for asylum a day. And let's say you're driving across. You get in line. It's about, like I said, about a 3-hour line. And once you get into the line in a car, you can't get out of the line, and the line goes on for quite a ways. If you were to, for example, find out that the 10 people have gotten in, then what? I mean, essentially what you're having people do is turn around and just keep recycling through the line. Because when it's 3 hours long, or 5 hours long, or 12 hours long, and this thing runs 24 hours a day, what are we doing here? So the other thing they were talking about are these turnstiles and arriving at and arriving. So I think that the way this was designed is, so we have the actual border, and we have just on the Mexico side, we have the U.S. Customs check-in thing where you go through and you talk to them and they say, are you going to be allowed through? And this is a Navy vet, what I was talking to you about. You cannot turn around without crossing it. Yeah. You can't, there's no way to turn around. You can't turn around. And then before you get to the part where they check you in, there's a line, and I think the idea was that before you got in that line, you were supposed to go through a checkpoint, or not a checkpoint, rather a turnstile. And that was, like I said, it was the same idea. Like you got in there, you went through the turnstile, and that was like the point of no return. The problem is the line keeps going for quite a ways. So you wait in line for hours to get to the turnstile. Nobody checks you at the turnstile. Then you keep going in line for more hours, and then they check you. So this is what, I think they were talking, when this is where they were having a lot of confusion, where they're like, well, the line, this point in the line, this point in the line. And it's like, well, at what point have you arrived? Is it really not until you've gotten over this point? And if they're going to say, okay, if you're here in the line and they say, okay, we're not letting anybody else go, okay, well, you can leave. If you're here, you can't. Not really. And even if you can, then what do? Just go to the end of the line again and just keep making this circle? Like, how is this supposed to work? This doesn't make any sense. What makes more sense is to just walk a couple of miles down the road and hop over. And that was the problem, is you're incentivizing people to break the law at that point, and then what? Then what are we doing? This, it's not making this any more efficient, because you're taking more people away from this little blue box where we're trying to process people faster, because they have to go over there and watch the wall and police it. So it takes resources away. So this was the whole thing a few years ago, was what we needed, more money and resources to make this system more efficient. Because if we process people faster, we can say yes, no, no, bye. And the problem solved. So instead of wasting resources by encouraging people to go climb a wall that we then have to police. So it's just bad policy that makes the whole thing worse. Anyway, that's just, okay. But I think that was part of the problem, is while they were sitting there talking about turnstiles and points in the line and everything, it was like visualizing this thing and how big it is hard to see until you've done it. Okay, and I'm sorry, a bunch of people are talking, and I don't mean to ignore anybody, but arriving should be interpreted as entering U.S. controlled land. And that's the other thing, is at what point are you in U.S. control? I don't really know. I don't have any idea. Is there no policy? You got me. And I was sort of expecting a little bit of clarity from somebody, and nobody seemed to have it. It's the border. They forget that we have to operate on our side of the border, but it's really unclear where the border is when you're there. I'll tell you that, because all of this feels American. Like, you feel like you are, especially once you get past the turnstile. And even, I'll tell you what's funny, I ended up, because we did it a lot, I ended up getting like the pass so that you could go through a lot faster. You actually have to go to the other side of the river, because they have this whole setup on both sides of the river. One is a faster version on one side of the river than the other, if you have the pass. But even with the pass, it's still half an hour or so. I mean, it's still long. Maybe longer than that even. So it is quite the process. So anyway, that's, I think, why what a lot of the confusion was about was some people have an image of what this is supposed to look like, and it just doesn't look like that if you haven't been through it. By the way, I've only been through one of these. I'll bet they all look different, so I can only give my own impression. The other thing is that I always have in the back of my mind, I used to, for example, I used to go every summer. We would go to the Boundary Waters. Anybody ever been up to Minnesota, up to the Boundary Waters, up in Canada, any of that area, 1,000 lakes, land of 1,000 lakes, whatever, 10,000 lakes? Every summer, my family, my brother, my dad, and I, and some other people used to go up canoeing and backpacking around there. And you just wander back and forth across the Canadian border. And you were supposed to go check in afterwards with the Customs and Border Patrol, but that was up to you. Nobody was watching. It was up to, if you got caught later and they realized that you had, then you could get in trouble. But it was a theoretical trouble. Nobody was watching. I believe that has all changed since 2001. I haven't done it since 2001. So, Lake, I don't know. It was a bunch of little lakes up there. I don't remember the name. It's been a long time. So when we talk about pre-2001 stuff, it was a different world. It was not the same thing. The argument that being in line is not having arrived, it's hard to swallow. It's that's what I'm saying. Being and particularly when there, like I said, there are these different stages of being in line. I do think this place was probably designed so that that turnstile was, you weren't in line before you got in the turnstile. I don't think that was supposed to be part of the line, but it is. Like, the line keeps going for a while. I mean, for hours. So, and what are you supposed to do if you find out it's closed? I I mean, you might as well stay in the line because they may open it back up again before you get to the front of the line. And if you're not from there, I mean, if you came all the way there, you might as well just stay and keep flipping your way through. Yeah, DHS didn't exist back then anyway. I mean, they had their own version of it, but okay. So but that was part of it. A lot of this was just like, did you guys prepare for this at all? But again, I also think that they didn't have some of these arguments just weren't great. A lot of with what we have to do with the TSA at the airports. Absolutely, this is all connected. One of the big problems I think here that we have, and this was something I dealt a lot with, I did try to do immigration law for a little while. I did not last in immigration law because it was miserable. And all I ended up doing, I was not super willing to take on clients who I felt I could not do anything for. You know, I didn't feel like I could take anybody's money if I didn't have anything I could do for them. And so I just kept getting people who wanted to be my clients that all I could say was, there's nothing I can do for you. And so I spent a lot of money, like advertising and stuff, a lot of money. And all it brought in were people who I would just say, I can't take you as a client because I can't take your money. And so after a while, I just completely gave that up. It was miserable. Anyway, but the point is that a lot of the problem is in that area is inefficiency. Like guys, like I can't even explain how badly inefficient and horrifyingly inefficient, and how much of the problem is rooted in mountains of inefficiency. And that really is the problem. It's not too many people. It's not any of that. It's the fact that we are so far behind on processing that nobody gets processed, and we don't know what to do. Cross-border control, you enter internationals. That's the thing. It's all kind of the Wild West. There's no good answer. Like when you get into that, that's like I said, it's where are you in this process? When do you enter the U.S.? I'll tell you, somewhere in here, you start to definitely don't feel like you are not being looked at pretty closely. So you don't. There's a point there where I don't think there's any question that if you looked at somebody wrong, you would be in custody by the United States government. And if that's not something close to being in the U.S., I don't know. Well, and that is I think Navy's got the nail on the head, which is that it makes a better policy for election than to fix it. Yeah, the hearing just ended. One of them, by the way, there's another one at 1 o'clock Pacific time. I said it wrong this morning. It is 1 o'clock Pacific time. There is, by the way, guys, I bring this out every once in a while when we talk about immigration. So I have this book here. It's actually signed by Jeb Bush. Jeb Bush's book on immigration wars, if you read it, you would think that it was written by, I don't know, who is considered a super lefty today. I mean, it is all about the absolute opposite of anything you would hear on Fox News. It's just all about trying to make it, please clap, but it's all about trying to make it efficient and clean it up and get it working, which again, really is the problem. Like, really is the problem. Yeah, something, Bernie, somebody, but it really is the problem. If we like cranked up the machines and just got all the paperwork processed, if we processed all the paperwork, everybody would be, there'd be nothing to complain about anymore. But, yeah, there's a lot of money wrapped up in not getting that done. But whatever. But also, though, I also am not sure everybody realizes it. But that might be me being too optimistic and too forgiving. Let me run back for a second and see a couple of things I wanted to bring up about the bankruptcy case. One of the big ones is because I knew this was going to be an issue, and I should have made a bigger deal about this in the morning report this morning. Why it is that we care about creditors' rights, and this was really important to me when I was working in bankruptcy. I always kind of kept this in my head because I always have to feel like when I'm working on something that I'm doing something good, which is creditors, credit card, because a lot of the work that I was doing was in favor of credit card companies when you're a bankruptcy trustee. And it's like, how can you, come on, how do you justify that? But the thing is, if the bankruptcy system, in theory, really screws over credit card companies. No matter how, well, it's not entirely true, but as a general rule, if you have $100,000 in credit card debt and you file for bankruptcy, it's gone. It's gone. And unless you own a bunch of stuff that's worth selling, but you probably don't, they're not getting any of that back. And it's just a loss for them. So for credit card companies to still exist and for them to not have lobbied the bankruptcy system out of existence by now, the only way for that to have happened is for bankruptcy laws, like the part that the trustee does, the work that I was doing, to at least be enforced. Even though it's still not a great deal for them, you have to at least enforce it the amount that it is enforced. How many average people are applying for bankruptcy? A lot. A lot. And most of my bankruptcy cases are what we call no asset cases, which means because when you file for bankruptcy, you're allowed to exclude, so what we do, we take everything you own, everything you owe, and in theory, we sell everything you own to pay off everything you owe. But if there's not enough money to pay off everything you owe, it doesn't matter because what you owe is gone. We just give them whatever you have. But the thing is, it's not everything you own because A, we only sell anything worth selling, and B, there's a bunch of exemptions. You're allowed to keep like a certain amount of stuff. It's like, let's say, I'm just gonna pick a number. Let's say 10 grand. It's more than that, but worth of stuff. It's like categories. We have 3 of this, 2 of that, 5 of that, whatever. And so all that stuff. After all that stuff is done, almost every single case that was on my desk, and by the way, I only got the complicated cases. There was a whole office full of people who just processed these cases all day. Almost every case they did, I would say 99.9% of the cases they did were what they call no asset cases, which just means they check a box that says there is $0 to sell. None of their creditors are getting a dime. Check. Folder is done. 90% of the cases I dealt with were, and I had the complicated ones, were still no asset cases. No money, none of the creditors got a dime. But we had to at least go through the steps of trying to enforce their rights to make sure, because like I said, otherwise the whole system, they wouldn't keep allowing this to happen. So that's why we bother enforcing creditors' rights in those cases, is because, and yeah, there's plenty of counter arguments, but that's how you do it and why you do it. And as the trustee, you're supposed to be a referee. You're supposed to be in the middle. You don't really care about either of them. You don't know either of them. They're just a folder on your desk, and you're just looking at the numbers on each side and checking them off and making sure that, you know, the numbers add up and closing the file. So, yeah, but there are a lot of people who file, and like I said, almost all of them are no asset cases, where the creditors get nothing. So, but that's why because I knew that was going to be an issue and something that people were going to ask about, and because it does sound like you're like, what do we care if they get anything? Well, that's we don't necessarily care, but we have to at least pretend to care. What else did I say? Oh yeah, and I said it's hard to get past a super abstract answer to that question because it's a complicated question. Yeah, but there's only like a couple per state. So anyway, that happened to be like my first job out of law school. It was supposed to be, I actually was hired to work there for 1 week, and then I stayed there for 3 years. It was fascinating. Let me think here. Oh, right. But that was why, you know, so I kept thinking like that was going to be a big issue, was that they weren't enforcing the creditors' rights. I was glad to hear they at least brought that up, and I do think that maybe Jackson will talk about that. They were talking about the fact that in this case, so this was a Chapter 13 case, not a Chapter 7 case, where the creditors were all paid off, which could be why creditors' questions weren't brought up. Conversions, if you don't mind. Hold on, wait. Can you remind me what the question was about conversions? Did I write it down? I probably wrote it down, but knowledge of duty. Will you ask me again, and I'll try to bring it back up. Yeah, so and none of the creditors objected, so it might not have mattered whether they were enforcing creditors' rights or not. Oh, can a bankruptcy court convert a Chapter 13 to a Chapter 7? So they can, but that is the punishment, basically. So Chapter 13, the deal with Chapter 13, in either one of them, you end up, if anybody watched the thing this morning, you end up setting up you get a, so like I said, you know, when you file for bankruptcy, you set up a bankruptcy estate. It says if the human being passed away, the person underneath crawls out and leaves. Goes and has their own life, okay? They leave behind this shell. That shell, called the bankruptcy estate, owns all the stuff, owes all the stuff. And me, the trustee, I wasn't actually the trustee, I was assistant to the trustee, comes and crawls in, takes it over, sells the stuff off to pay the people off. And that is Chapter 7, liquidation, where you just liquidate everything, sell it off, and then that's the end. Chapter 13, instead, we let the person keep using their stuff, and at the end, we let them have whatever's left back. They can keep it all at the end, as long as, in the meantime, which is about 3 to 5 years, we pick a number based on how much money they have and everything. They agree to make monthly payments every month so that at the end, they've paid the most that they can that I, as the trustee, will distribute to all their creditors. And as long as they make their payments all the way through that 3 to 5 year period, they can have all their stuff back. And in the meantime, they can use their stuff. And so it's it's a nicer deal for them. It's a much less painful situation for them, but it's still a situation where there is an estate set up that owns all the stuff, even though they're using it. In a conversion happens from a 13 to a 7 when they stop paying. If they stop paying, I, as the trustee, eventually have to put the smack down and be like, look, we had an agreement, you stopped paying. So I'm gonna have to turn this into a 7 and sell all this stuff. Sorry. And once you open a bankruptcy, you don't own any of it anymore and you can't get it back no matter what. And that's happened before. That did happen to us a couple of times where somebody opened a Chapter 7 and then realized something they owned was worth a lot more than they thought, and they tried to get it back. And it's like, sorry, like, that person died when you signed this. This is an estate. You left. So it's over. But why is the tort claim subject to creditors in the first instance? So, if in Chapter 7, if there's some sort of an injury that happened before the filing date, it would have belonged to the estate, the person who died, right? That claim now belongs to the trustee. So the trustee can go enforce it. In a Chapter 13, if the person gets hurt in that next 3 to 5 years, it still belongs to the estate. And because it's part of the income coming in to the estate. It's a little weird because you feel like the person crawled away, but for some reason, because it's the income coming in, it's still part of the estate until the end of that time period. And so anything that happens during that time period that creates income is property of the estate. So that's why. 13's a little weird. I actually had to look it up because I didn't work in 13. I only worked in 7s. So understanding how the estate worked in a 13, I had to look up because I learned it in bankruptcy class back in 2011, but I had to relearn it a couple days ago to remind myself. If you got off the plane in an international flight and have not passed, I don't remember. There's some fuzziness there. Keathley was really a moot case here in some ways. Yeah. That was the thing, is that the debt. So the debt was, that was the thing, is that they were, and they could have said that, and that was the thing, is that if in this case they'd all been paid off anyway, then maybe that was the point, but then they needed to say that. So I hope that's what they say instead of making a rule. I don't want them to make a general rule that excludes the role of the trustee in all this. And yeah, and they also said that none of the creditors objected because they were all getting paid. They didn't have anything to object about. They all got their money, which is not common. Most of the time, the creditors get pennies on the dollar is the kind of phrase you use. For the $100,000 debt, they end up getting $1,000 or something, even out of the whole thing. So if more money comes in, they're going to care. That's why I was worried about them making a rule from this instead of just saying, well, in this case, it didn't matter. So, let me see here. Oh, and then evidence related to knowledge of the duty. I married a legal criminal asked about evidence related to knowledge of the duty. So this is about know or should have known, I think. So, if you have a duty to do something, it's It's one thing if you don't do it. But if you didn't know that you had to do it, that can be a different thing. It's a difference between know or should have known. And sometimes there needs to be evidence that proves that you knew you were supposed to do it. So that would be evidence related to knowledge of the duty. And sometimes only in very specific, if there's a very specific requirement that not only did you have a duty to do something, but you had to know that you had a duty to do something, that for the court to win the court case, or lose the court case, whatever, that somebody's going to have to provide evidence that you knew that you had a duty somehow. And sometimes you can do that. Oh, well, this person comes along and says, oh yeah, I told them. Okay, well, there you go. There's your evidence of knowledge of the duty. So that was what someone asked me. I still want to know what happened with that attorney. I don't know why that wasn't in the record. How did they not have that in the record? That the attorney was told that this happened. Yeah, married, and didn't tell them, or didn't bring it up. So okay, I married a legal. Did that answer your question? I wonder why. For some reason, the text isn't showing up all of a sudden in the. Let me see here. I don't know why that's happening. Yeah, fire away. But did I answer you at least? Yeah, probably. But they asked, so I wondered why. I was like, come on, nobody's going to give us the answer to that question. And I apologize, Vashon, you were just asking me stuff, I think, and I didn't realize that for a minute my this wasn't coming up. Oh, you're asking me specific stuff about service process. I have no idea. I would have to look that stuff up. And it's going to be different every court. That's going to be that's going to change from court to court. So I have no idea. Sorry about that. That's one of those things that that's local procedure. Local procedure. Okay, guys. So we are down to let's see. We have one more day this week of we got one more day tomorrow. I'll tell you. So tomorrow we're going to talk about arbitration. I'm going to do the morning report mostly just teaching you about arbitration because I think people want to know what it is, and I feel like we should go into it knowing what that is. The case itself is about whether somebody gets an exemption from the Federal Arbitration Act. So that sounds a little boring, but I'm going to try to make it interesting. But then we have all next week, and particularly next Wednesday is going to be important. Today, 4 o'clock Eastern, 1 p.m. Pacific, is that call, the Zoom call for the Anthropic case. You can find the link either in my morning report video or on my stack. There's like a clickable link on the stacks. I think that's going to be interesting. I'm hopefully going to be not passed out by the time I get there. If anybody is, if you want, please consider checking my links we're gonna run towards the end of the month, and I haven't even started fundraising, which I still have to, gotta keep the machines running. So please consider that. Let's see. Whew, I'm running out of energy. Yeah. Okay. That's it. Yeah. So I'll have a morning report for you tomorrow morning on the case for tomorrow and some updates, and probably I'll catch up on. I'll try to catch up a little bit on whatever happens in that case today. Go check out that case this afternoon. It should be interesting. That is some scary AI stuff. Go check out my links. My link tree is the link in my bio. Go check out my Venmo, stuff like that. That would be awesome. Or my wish list. I would appreciate it.